Good morning, everybody. Welcome to the virtual hearing for the inquiry into budget estimates 2021 to 2022. Before I commence, I'd like to acknowledge the Gadigal people, who are the traditional custodians of the land on which the Parliament sits. I'd also like to pay respects to elders past, present and emerging of the Eora Nation and extend that respect to other Aboriginals viewing this broadcast. Today, the committee will examine the proposed expenditure for the portfolios of customer service and digital. Today's hearing is being conducted as a fully virtual hearing, which enables the work of the committee to continue during the COVID-19 pandemic without compromising the health and safety of members, witnesses and staff. As we break new ground with this technology, I would ask for everyone's patience through any technical difficulties that we may encounter today. If participants lose their internet connection and are disconnected from the virtual hearing, they're asked to rejoin the hearing by using the same link as provided to them by the committee secretariat. Before we commence, I'd like to make some brief comments about the procedures for today's hearing. There may be some questions that a witness could only answer if they had more time or with certain documents to hand. In those circumstances, witnesses are advised that they can take a question on notice and provide an answer within 21 days. All witnesses in budget estimates have a right to procedural fairness, according to the Procedural Fairness Resolution adopted by the House in 2018. Today's proceedings are being broadcast live from Parliament's YouTube channel, and a transcript will be placed on the committee's website once it becomes available. Finally, a few notes on virtual hearing etiquette to minimise disruptions and to assist our Hansard reporters. Could I ask committee members to clearly identify who questions are directed to? And could I ask everyone to please state their name when they begin speaking? Could everyone please mute their microphones when they're not speaking? Please remember to turn your microphones back on when you're getting ready to speak. There's always one in every hearing though, so don't be too embarrassed. If you start speaking while muted, please start your question or answer again so that it can be recorded in the transcript by Hansard. Members and witnesses should avoid speaking over each other so that we can all be heard clearly. Also, to assist Hansard, may I remind members and witnesses to speak directly into the microphone and avoid making comments when your head is turned away. All witnesses will be sworn prior to giving evidence. I will start with you, Ms. Hogan. Could you please state your full name and position and swear either an oath or affirmation from the cards that have been emailed to you by the Secretariat?
Yes, thank you. Good morning, everybody. I'm Emma Hogan, the Secretary for the Department of Customer Service. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr. Dent, could you please state your full name and position title and swear either an oath or affirmation?
Good morning. Adam Dent, Chief Executive, the State Insurance Regulatory Authority. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Dent. Mr. Rees, could you please state your full name and position title and swear either an oath or affirmation?
Good morning, everyone. Damon Rees, Chief Executive Officer for Service New South Wales. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given to me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Rees. Mr. Brady, could you please state your full name and position title and swear either an oath or affirmation?
Good morning, Stephen Brady, Chief Operating Officer. I swear the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. And last but certainly not least, Ms. Webb, could you please state your full name and position title and swear either an oath or affirmation?
Good morning, Rose Webb, Deputy Secretary of the Better Regulation Division. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. So today's hearing will be conducted from 9:30 until 11 a.m. and from 11:15 a.m. to 12:45 p.m. with questions from the opposition and crossbench members only. If required, an additional 15 minutes is allocated at the end of the hearing for government questions. As there's no provision for any witness to make an opening statement before the committee commences questioning, we will begin with questions from the opposition.
Thank you, Chair. Good morning, everyone, and thank you for your attendance. I'm Anthony D'Adam, the Labor member of the Legislative Council. I might start my questioning with Mr. Rees. I'd like to ask some questions about Service New South Wales rollout of the business grants assistance schemes. There's been a number of sort of adverse reports in the media in relation to delays in terms of the processing. I'm going to refer to an article that was published in the Sydney Morning Herald on the 8th of August. And my first question really relates to the question around benchmarks for decision making. The article suggests that there's a 2 to 7 day benchmark for processing an application in relation to the business support program. Mr. Rees, is that benchmark being adhered to?
So thank you for the question, Mr. D'Adam. Maybe just a little bit of context before I get to that specific, because there's a lot of information that relates to these programs. The first is there's 3 primary programs that are being delivered at the moment. The first is the small business grant, which was opened for applications on the 19th of July. And then the micro business grant and JobSaver were opened a week later on the 26th of July. There are a range of other support and stimulus measures also in place, but I think those 3 programs represent where the majority of the focus has been. There's a number of steps to how we process, assess, and pay applications. Without sort of getting right into the detail there, our aim is to pay applications, pay eligible applications within 4 to 8 working days of receiving them. Our average across all programs at the moment sits at about 8 days. We do recognise that.
Did you say that your intention is to pay an application within 4 to 8 days of receiving the application?
So our goal is from the point at which the customer applies for eligible applications. Our goal is to pay those applications within 4 to 8 working days. The average across all the programs to date sits at about 8 days. I certainly do recognise there's been some customers, particularly those that applied earlier in the programs, that would have experienced delays longer than that, but the average overall is just over 8 working days.
But I just want to clarify. So you're saying that from the date that the application is lodged, the average is 8 days before money arrives in the applicant's account. Is that what you're saying?
That's broadly correct. That's right. Applications, the way that calculation of 8 days is derived, it captures all applications. So if we do have an application that has not yet been paid, we will calculate that from the date at which that application was made up until the present time. So it doesn't exclude any applications. But yes, that's the average representation across all applications received.
So does that include the time to? So what's the benchmark then in terms of making a decision on an application within that 4 to 8 days? How long will it take for a decision to be made on an application?
So the timing for the decision can vary between programs and between applications. In some programs and for some applications, we will automatically assess and approve those applications. So there's effectively no delay and same-day approval. For some of those programs and for some applications, that will require manual assessment, and the level of manual assessment will depend in part on the business that's making the application and the program that they're applying for. We typically have a 3-stage process for manual assessments. So stage 1 looks at the applications, identifies whether there's any information that is missing from those applications, and liaises with customers to try and address those missing aspects of the application. Stage 2 is then our assessment step, where we look at those applications and determine eligibility. And stage 3 has a final review and an approval step before funds are then processed for payment.
And does that decision all rest with a single assessor, or is there multiple layers within the assessment process?
So there's multiple layers. As I said, that 3-step process. Step 2 is where the assessment effort is taking place, and then we have a separate third step after that, which acts as a quality assurance of the assessment process, and where the delegations are held for the final approval of those assessments. We will vary that process over the life of the programs as the understanding of risk within those application sets changes, but there's 3 steps applied.
In the article that I referred to earlier, there was an example of a business that was applying for both the COVID business grants, the initial grant program, and then for the Job Saver. And they indicated that those applications were being considered in 2 separate processes. And I wanted to just get some clarification around whether there's some streamlining, or if that's the case, is it the case that those applications would not be joined together and assessed in a single process?
Yes, so we have 2 different. So firstly, I'd say the eligibility for those 2 programs has some areas of difference. We do assess those applications differently, and for the Job Saver program specifically, the assessment for that program is performed by Revenue New South Wales as opposed to Service New South Wales. So there are 2 different processes and 2 different teams involved in the assessment of those applications. We do apply some business rules to identify the synergies between those programs. So as an example, if you've applied for both programs, if we've assessed you on the Job Saver program, which requires a turnover reduction of 30% or greater, then that automatically meets the threshold for the lower payment on the business grant program, and so we can apply some of that logic and those checks between the assessment of those programs to identify where we can automatically approve the other payment without an additional duplicate manual inspection.
Can I ask how many businesses would have applied for the first grant program and then subsequently applied for the second? What's the sort of percentage in terms of the number of return applications?
Yeah, I don't have the exact percentage to hand, but certainly more than half of the businesses that have applied for the first business grant program have gone on to apply for the Job Saver program. One of the key differences between the programs is the period in which the business needs to have been impacted as a result of restrictions. So the business grant program very much related to the first 3 weeks of restrictions, and so some businesses found that they were impacted as a result of that first 3 weeks and are eligible for that business grant program. Both Job Saver and the micro business program really then take over after that first 3-week period, and so there's some businesses that are impacted through both of those periods. There's some businesses that were impacted just in the first period but not subsequently, and there are some businesses that were impacted in the subsequent period but not in the first 3 weeks.
So coming back to your original statement around the benchmarks, on the evidence that you've given, you're meeting the benchmark. The 8-day is the sort of outer limit, and you're meeting that. So can you explain why there's still so many backlogged applications in relation to the business grant program? I think I had on the information that was available yesterday, 32,783 applications were still in progress. And it's a long time since that program was put in place. Why is there such a backlog if you're meeting your benchmarks?
Yes, so maybe 2 comments. The benchmark that we've quoted is an average. So of course some customers will experience lower than that. Some customers would have experienced higher than that. We certainly recognise, particularly in the first couple of weeks of the program, there were certainly customers that experienced a longer period having their applications assessed and their payments received. It's important then to understand the remaining that there will always be applications in progress to be assessed in these programs. We continue to receive applications on a daily basis. Almost half of the applications that have not yet been processed are actually waiting with our customers to either confirm that they would like to finalise their application, particularly in the case of microgrants, or to provide additional information to either support their application or clarify a question that the assessors have. The figures that you've referenced were updated again this morning to reflect the progress as of end of yesterday. And so you'll see there's about 26,000 applications that are still to be processed. They range from applications that are received from today, and we have a small percentage of those applications that are aged more than 2 weeks. All of those applications are to be assessed for really one of two reasons. They're either an application from a business that is in an industry that has not been identified as highly impacted by the restrictions that have been imposed. So there's some industries where we recognise there's a very clear correlation between restrictions and the impact on the business. Cafes, restaurants, tourism, pubs, etc. There's a range of businesses where that correlation between restrictions and the subsequent impact on business turnover is not clearly or universally understood. So computer consultancy might be a good idea. A good example, sorry.
Mr. Rees, I've got a limited amount of time, so I might move you on. I want to ask about staffing. I see that the number of staffing in terms of assigned assessors, are they Service New South Wales employees, the assessors?
There's a combination of people involved there. So the assessors are principally made up of three groups. We have Service New South Wales employees, we have Revenue New South Wales employees who are principally focused on the JobSaver grant, and we have some third-party support involved in assessment as well.
So in terms of, I'm looking at yesterday's data, so I apologise, but in terms of the 650 additional assessors, what is that the sort of upper limit? How many of those are staff that have been added to Service New South Wales' employee numbers since this program was implemented?
So 650 is the upper limit of the number of assessors we've had working on a single day, and it's the combination of all three of those groups: Service New South Wales staff, Revenue New South Wales staff, and third-party support. Within Service New South Wales, we've added beyond the people that have been reprioritised from other activities. We've added between 200 to 300 additional people into the organisation for the purpose of assessment. That's separate from the people that have joined the organisation to provide increased capacity for customer service and support for our business clients.
I see. So the 350 additional staff to answer customer inquiries are separate from the assessor numbers.
That's correct.
And those assessors, are they being drawn from other parts of the department?
So that they are principally Revenue New South Wales. So a significant part of the assessment capacity has been drawn from Revenue New South Wales. Revenue New South Wales have reprioritised some of their workforce from other activities to support the assessment of these programs, particularly JobSaver, but have also provided some assessment support for the small business grant as well.
Ms. Hogan, the last budget had a $37 million cut to the department's budget. That was predominantly going to be taken through employee-related cost savings. Where is that budget cut up to in terms of implementation? Is that now off the table given the surging numbers to meet the requirements of the implementation of these programs?
Yeah, we have full funding support for the additional people that we've required for all of the COVID resources that Mr. Rees has referred to there.
So that 37 million is gone now. That cut won't be given effect to, or will there be some additional cuts elsewhere to try and meet that, given the need to shift resources around these programs?
So I might refer to Mr. Brady on the 37 million specifically. I don't have those numbers in front of me, but my view as the Secretary is that we are appropriately funded and funded properly for next year. And then we get additional and have received in the last 12 months additional financial support when we've needed to ramp up resources for initiatives such as these.
Mr. Brady.
Thank you. I think I'd have to take your question on notice. Our overall expenditure budget actually increased in the last budget.
That's if you're going to take the question on notice, Mr. Brady, I might move on because I have fairly limited time. Mr. Rees, can I come back to you? I want to ask about this, the arrangement in terms of headcount requirements for both the business grants program and for the JobSaver program. Can you explain to me why the headcount arrangement was put in place? Is that a question that you're able to answer?
I don't quite understand. Could you just clarify the question, Mr.
So the JobSaver program and the earlier business grants program were intended to effectively to preserve the relationship between employees and the business. There's the mechanism that's been put in place is this headcount arrangement where the business has to make a declaration about their headcount and then they have to maintain that. And I've got a series of questions about how that will operate. Are you in a position to answer those questions?
I can certainly attempt to, yes.
All right, so I wanted to ask about the arrangement with casuals. So if a business has casuals as part of their headcount, are they able to just reduce their hours to the minimum and still receive the full amount of the grant in terms of JobSaver and the business grant program?
That is my understanding. So if if an individual's employment is maintained, but their hours are reduced, my understanding is that does still meet the requirement to maintain headcount, and that business would remain eligible for the support of that program.
And so would those employees then be eligible for the disaster payment?
From the Commonwealth, yes, that's my understanding.
And does that in any way impact the amount that's then paid to the business in terms of the JobSaver? Oh, well, let's just focus on JobSaver for the moment because that's the one that's currently in place.
No, I don't believe so. So the JobSaver payment is to the business to support that business, and one of the requirements there is for the business to maintain headcount. The individuals of that business, should they experience a reduction in wages and access Commonwealth support, I do not believe that impacts the payment of JobSaver to those businesses.
And what kind of auditing arrangements are in place to ensure that the headcount is maintained while this business is receiving this support?
So currently that's based on an attestation from the applying business. There are of course significant consequences to businesses that don't provide correct information as part of their applications to Service New South Wales as a government agency. We're in discussions at the moment with the policy owner of those programs, being Treasury, around what the compliance activities following the delivery of the program will look like.
So one of the requirements is that a business notifies if there's a change in headcount. What happens if they don't notify? What's the consequence? It's not clear in the guidelines what the consequence is of a business that doesn't notify of a change of headcount.
So the obligation is on the business to notify of any change to any aspect that may render them ineligible for those ongoing payments as part of the JobSaver and the micro grant programs. We'll be introducing an explicit step moving forward requiring businesses to confirm that their situation hasn't changed, that they remain impacted and they remain eligible for ongoing payments, and also providing them, with an easy mechanism to withdraw payments. All payments are being made as active grace payments, which means if businesses are found to have received funds incorrectly where they were not eligible, then Revenue New South Wales will be able to utilise its powers in order to reclaim those funds for government.
Mr. Rees, can I ask you about the Commercial Landlords Hardship Fund? This was an announcement that was made by, I think, Minister Tudor-Hope on the 13th of August. There's still no details on the Service New South Wales website about this fund. It's almost 2 weeks. Why is that?
We're seeking guidance on priorities for the delivery of a number of programs. One of them is the Commercial Landlord Fund. Another is the program that was announced to support accommodation providers where they had cancellation in bookings. We're just working through the prioritisation of the delivery of those two programs. And once we get that guidance, we'll have an update on the website and a time frame for those applications available shortly.
The website says information will be provided soon. Can you give us a specific date about when that program will be up and running?
That prioritisation question was posed several days ago, so I'm expecting finalisation of that today, and we'll aim to provide guidance by the end of the week.
Okay, thank you. Can I ask about the amount? The 40 million is it's not a lot. How many commercial landlords do you think will be assisted by this fund? Is there modelling on that?
I'd need to take that on notice, Mr. D'Adam.
Okay. Can I ask about call times? So coming back to the data, there was some adverse comments in the media around people being required to wait for extensive periods of time on the phone. I wonder whether you're obviously running a very big call centre operation. You'd have extensive data on this. I wonder whether you'd be able to provide on notice what the sort of outer limit, like what's the longest call that you've received in relation to this this program, and what's the longest wait period that someone has had to wait to have their call taken in relation to an application for any of those three business support programs that we discussed earlier. Are you able to, do you have that information at hand, or?
I can certainly address the majority of that, and happy to take anything else on notice. We, with the introduction of restrictions and the introduction of support, we saw a approximately 4,000% increase to inbound calls from business customers in a very short period of time. So certainly our average wait times did spike significantly, and our customers did experience extensive waits of 2 hours or more trying to reach Service New South Wales for a period there. We responded to that by reassigning and recruiting additional support. I'm happy to say that those average wait times as of yesterday were down to 7 minutes. We aim to keep those average wait times below 10 minutes. They do still
move. What's the median wait time, Mr. Rees?
The median is the average. That was seven minutes yesterday.
The median is the average. What's the median?
Oh, sorry, median. I don't know. I'll have to take that on notice, Mr. D'Adam.
That on notice, thank you.
So we aim to keep those wait times for business customers less than 10 minutes. They will still move up and down a bit. As you can imagine, it's a very dynamic operating environment. So as an example, the recent introduction of requirements for permits relating to work resulted in a significant increase in calls from business customers, and also the expanded restrictions across parts of regional New South Wales, are drawing more customer questions and more applications and support for grants. So whilst we aim to keep those wait times under 10 minutes, from time to time they are still going to increase. But I think we have we're certainly in a good place at the moment.
Thank you, Mr. Rees. The opposition's time has expired for this round. I will hand over to Mr. Banasiak.
Thank you. So Mr. Banasiak here, my line of questioning might first start with you, Mr. Rees. Just touching on what the opposition has spoken about in terms of the delay in processing. Am I right in saying that we seem to perform this task a bit better the last year? There didn't seem to be as many complaints about getting these grants and support actually processed and out to customers. Can you explain that perception? Why have we sort of, struggled this time around?
Thanks for the question, Mr. Banasiak. I think from my perspective, there's probably two key differences this year compared to restrictions last year. One is the restrictions are more extensive and are impacting more businesses to a greater degree. I think the other comment I'd make is that there are more elements to the government response. For some of our customers, there's been some challenges understanding how the different programs work together, which ones are for them, what combination to apply for. And certainly from a Service New South Wales perspective, that has expanded the complexity to stand up 3 programs in rapid succession, and the significant volume of work that comes with that. But what I would say is, as we stand now, 4 weeks into 2 of those programs, 5 weeks into the other, we have paid $2 billion out across those programs. And I was saying before that the applications that remain outstanding and are currently being processed they're typically for one of 2 reasons. One is they're from a business that is in an industry that has not been highly impacted by the restrictions more broadly, and so we need to really understand, what is the impact of those restrictions on a case-by-case basis. The second reason an application may still be requiring processing is it has triggered some form of flag, whether that's related to fraud or whether that's a question mark around eligibility, and then further analysis and typically engagement with the customer is required to enable those applications to be finalised. All the applications that we've received from businesses in industries that have been highly impacted and are complete and eligible applications have been processed.
Okay. Are you receiving more applications now from the regional areas? Because a lot of regional business owners have contacted me and said they feel they're being disadvantaged because they're having to compare the downturn from the date of the Greater Sydney lockdown, not necessarily when restrictions hit their location. Do you have any data on that, or any answer as to why they're having to compare their downturn based on the Greater Sydney lockdown date?
I think there's a little bit of misunderstanding around some of this, Mr. Banasiak. So the business grant program really relates to that 3-week period of initial restrictions of the 26th of June to the 17th of July. It doesn't matter where your business is located in New South Wales. If the result of the restrictions that were put in place in that 3-week period impacted your business, in a way that makes you eligible, then that application is for you. To apply for that or to demonstrate that turnover impact, there was a number of choices that are available to businesses. So you can pick a 2-week period within that 3 weeks and contrast it with the same period either in 2020 or 2019, or you can contrast your impact in that period to the 2 weeks prior to restrictions. So I think there's a range of things there that I think cater to the vast majority of businesses, and really they're trying to enable a business to demonstrate what normal looks like and to be able to contrast that to the impact on their turnover as a result of those restrictions. For businesses that are more recently impacted, for example, as a result of the expanded restrictions, then actually the JobSaver or the micro grant programs are the programs that will be relevant for them. If they weren't impacted in that first 3-week period, it's the JobSaver and micro grant periods that are relevant. Similarly, they can demonstrate turnover impact in those same ways. They can either compare to the same period in one of those 2 prior years, or they can compare to the period immediately prior to the restrictions impacting them.
Okay. Can we just go back to those dates that you mentioned, the 26th of June to the 27th of July? Sorry, 17th of July. Why was that date range changed? Because originally the original documentation that business owners saw when they got onto Service New South Wales was the 26th of June to the 27th of July, and then about a week and a half later, the date range was changed, and it was only sheer dumb luck that people realised that the goalposts had been moved. So, can you explain the rationale as to why the date range was shortened?
I believe the answer is because the JobSaver program then kicks in and picks up the businesses that are impacted after the 17th of July. But the policy owner for those decisions is Treasury. So I'd ultimately need to refer the question there.
What steps did you take to make sure customers were notified of that change of the date range?
I can't recall, Mr. Banasiak. I need to take that on notice.
Okay, sure. Just going back to actual Service New South Wales centres, what reprioritisation of staff has occurred due to the lockdowns at the actual centres? Like, have you moved people out of those centres? Have they been put onto other functions? And I guess what services aren't actually being offered at the centres at the moment? Is there a list that's available to people?
There is. So look, our service centres, like all frontline service teams, are managing sort of the risks and the impacts of COVID and transmission. We've had probably about 30 different instances of impact through COVID positive customers, or in some cases team members, visiting Service New South Wales service centres. So it is a very live and active issue that we're managing. One of our key responses there has been to limit face-to-face service delivery to essential transactions only, and we've worked with partner agencies like Transport to provide a relaxation of policies to enable the deferral of any transactions we can. You know, driver testing's a really good example where we've worked with Transport, and as a result, we've been able to defer, I think, something like 50,000 driver tests that would have otherwise taken place through that period. I think that's a very, very important thing for our customer safety. I think it's a very important thing for the safety of our team. The impact of of those various points of contact has forced us to revisit our opening hours and to revisit our staffing models to attempt to provide a continuity of service whilst we're managing through that impact and its impact on the availability of our workforce.
Is there a list of these essential transactions somewhere on your website that's easily accessible for customers? I went on there just recently and I couldn't see anything sort of front and center.
I believe so. I'll certainly check that, and we can we can provide that link or that material across to the.
Yeah, even I noticed a direct link that we can provide to our constituents would be great.
Yep.
I think that might be close to my time. Not getting a nod from somebody.
Sure.
Yeah.
Let's move over to Mr. Shoebridge. Are you ready?
I am. Thanks, Chair. Thanks, Deputy Chair. Thank you to all the witnesses for coming today and for the work you've been doing. Mr. Dent, I might start my questions with you.
Sure.
In the last 24 hours or so, iCare has updated its facts sheet about protections for workers if they have a vaccination for COVID and have an adverse reaction. Do you want to just briefly speak to that?
I can, Mr. Shoebridge, thank you. While I haven't actually read the iCare website update on that particular matter last night, I'm aware of it. It would be in relation to providing guidance to insurers that should somebody have an adverse reaction to a vaccination, they would, through the normal process, be able to make a claim for workers' compensation if it was related to work. What would be required at this point in time is to demonstrate that there was a causal connection to their employment. and that a significant impact occurred. In the main, we would probably expect those claims would be treated as normal and would likely be considered as possible to be accepted. So that guidance is going to have to provide insurers with some interim information on how to handle those.
Mr. Dent, I'm not going to hold you to account for the wording on the website, but I'll just read you the sort of one of the critical paragraphs for workers. It says, the link between the vaccine injury and the worker's employment is easier to establish where a worker is influenced by their employer's requirement to get vaccinated or is subject to a New South Wales Government public health order. In these circumstances, there is an increased likelihood of the vaccine injury being covered under workers' compensation. There's a lot of uncertainty in that, isn't there, for workers? A lot of uncertainty.
Well, that may well be true. I think it does establish that if a causal connection is there, and as you say, a public health order direction or an influence by an employer would certainly be a decent consideration. So that it's not perfectly certain, obviously, but if it can be demonstrated, then it obviously will be considered.
But iCare can't say, because it's not your understanding of how the law operates at the moment, that if you're required to get a vaccine and you have an adverse reaction, you'll definitely be covered. There's still a significant degree of uncertainty and that requirement to go through that 4-step process that's set out on the fact sheet. Is that right?
That's correct. The legislation doesn't provide any presumption at the moment.
Given we want to do everything we can to address vaccine hesitancy and encourage people to get vaccinated, has iCare done some modelling about what the costs would be if there was a guaranteed cover for workers who were required to be vaccinated by work if they had an adverse reaction? Have you done some initial estimates?
I'm not sure if iCare have. To answer your question specifically, Mr. Shoebridge, I suspect you might mean CIRA.
I meant CIRA, yes. I'm sorry.
So CIRA has asked our actuaries to start putting some advice together for us. At the moment, that advice hasn't been provided in any final format, but we have asked, should the impact start to be seen, what would that look like? Early indications would suggest that without stronger guidance on what a presumptive model would look like, that provides huge variation between the sort of the boundaries of how much that might cost. So we're obviously concerned that whatever decision is made provides the right support to somebody who's injured, but equally make sure the scheme is sustainable. So I haven't got any final advice on that yet, but we have asked for it.
You know, the construction union in particular have been strongly advocating the need for an unambiguous presumption that if you're required to be vaccinated for work and you have a significant adverse reaction, you should be protected by workers' compensation. You're aware of those calls from the construction unions?
I am, Mr. Shoebridge. I've seen those calls, and we have had some early conversations ourselves with the CFMEU in particular, and we've seen correspondence that they've written to the Minister's office. CIRA is looking to provide advice to the Minister on that. Ultimately, a decision around what is legislated is a matter for government, but we'll provide advice on the sustainability of the scheme in that respect.
Mr. Dent, I'm tempted to ask you whether or not you think it's the right thing to do to ensure workers are covered in those circumstances. I personally do, but I understand it's not your role to provide that policy outcome, Mr. Dent.
That's correct. That's a matter for government.
There were a series of changes made last year to provide presumptions in favour of frontline and essential workers that if they contracted COVID, they would definitely be covered. I know that provided at least some sense of protection and certainty for those workers. Can you tell us what the cost to date of those claims under those amendments have been?
I don't have those numbers to hand. I'd have to take that on notice.
Do you have the number of cases that have been, number of COVID-related workplace cases that have been made in this scheme, the number of claims made and the number of claims accepted?
So I do. The number of claims and notifications, so some of them have been notifications rather than complete claims, is 759. We publish that data in our open data section of our website, so that's all there and was updated as at the 20th of August, so that's available now. So we do know that the number of claims hasn't necessarily been as high in 2021 as might have been estimated, but the number of claims and notifications to date is 759.
Mr. Dent, can you provide us any insight into how many of those claims have been in the current outbreak since mid-June onwards?
I'd have to come back to you. I'll ask the team to follow that up for me, give me the number in relation to the current outbreak.
If you could get that data during the currency of today's hearing, that would be really useful.
Yes, absolutely.
Do you know what the actuarial estimates were for the cost of those amendments last year? My memory was it was in the very many millions of dollars. Do you know what the actuarial estimates were for the cost of implementing those changes last year?
Respectfully, Mr. Shoebridge, at 7.5 weeks in the role, I suspect your memory might be better than mine on that. I'd have to take that on notice and come back to you. I do know we had actuarial advice, and it was that the cost could be significant.
So if you could come on, provide the answers as soon as you
absolutely.
can about what the estimates were and then what they actually have been in reality to date, that would be very useful.
If I can't get those in this session, I'll take that on notice.
Mr. Dent, we are now seeing, looking at the Doherty modelling, at 385,000 COVID cases across the country in the first 6 months. If we open up at 70%, then 80% progressively using the Doherty modelling. Has CIRA been looking at what the likely costs will be to the workers' compensation scheme if those sorts of case numbers actually happen in reality? Have you had a look at what the costs will be?
I can't say for certain that we've looked at that as part of the modelling around presumptive workers' compensation claims. Should a worker be affected, should that we reach that status? So I don't think the answer is yes, but certainly if we have anything else on that, I'm happy to take that on notice. I know it may be something we could ask to be considered as part of the advice we're getting in relation to presumptive vaccinations.
I suppose, Mr. Dent, it may be relevant to the presumptive work, but my question was more broadly under the current scheme. I'm talking about people going and working in a supermarket and getting COVID, or people in the transport industry and getting it through their meeting people at the depot, or those essential workers. We know that they're going to be, very likely, if that path is followed, a surge of COVID-related claims in the workplace. Is there no estimate being done using the Doherty modelling about what the likely impact that will have on the workers' comp scheme?
I haven't to date seen that. I can't say for certain that means it hasn't been considered by our actuaries at this point. If you don't mind, I might just come back quickly to the question you asked before. The number of notifications since the Bondi cluster commenced was 74. So 10% of the total at this point in time. But I will come back to you on whether our actuarial advice has taken into account the Doherty modelling at this point in time.
Do you have any insight into where the claims have come for adverse reactions from vaccines? How many claims have been related to adverse reactions from vaccines and where that might be sector by sector?
In relation to vaccines, I don't know that there's been a significant number of claims whatsoever to date. So the number I just stated is in relation to COVID cases, people with time off work due to contracting COVID. I don't have any information that suggests a significant number related to vaccines at this point in time.
I had heard that there had been a significant number of cases related to police, and indeed something in the order of 90% of those kind of cases had been from police. Do you have any visibility at all on that data?
So that would be in relation to contracting COVID rather than vaccines. I think just to be clear, Mr. Shoebridge, that's the distinction between those. Of the notifications, I think you're correct that a significant proportion of those were from police. That's not necessarily all claims, but out of all of the claims and notifications, a significant number related to New South Wales Police, where they related to the Treasury Managed Fund claims. That's correct. It was, I think perhaps I recall seeing a number around 91%.
Now, is that 91% of all claims of the 720 odd over the course, or is it 90% of the 74 claims we've had since the middle of June, or is it 90% of the Treasury Managed Fund claims related to the public sector?
My recollection, I don't have that in front of me, my recollection, it was 90% of the Treasury Managed Fund portion of the claims over the course of the pandemic.
If you could just give us a breakdown on the Treasury Managed Fund claims, including nurses, healthcare workers and the like, that would be really useful.
Happy to take that on notice.
Thank you. Apologies to both of you for interrupting your lovely conversation. It's very useful, but I need to pass on to the opposition. Opposition time from now.
There's no apology necessary, Chair. Thank you. John Graham to Ms Hogan. A week and a half ago, a plan was revealed to grant Star Casino access to 1,000 more poker machines. The reporting indicated it would be an increase in the cap of 1,500 to 2,500 machines. It also indicated it may require legislative change and it may involve a commitment to build 2 additional performance spaces. The plan was well received by investors, with the share price increasing 6.3% and the value of the company increasing by more than $200 million at one point. What can you tell the committee? What can you tell the public about this plan?
I might ask Ms Webb to respond to that question, Mr Graham, if I might.
Certainly. So what the government has agreed to is commence formal negotiations, and so the details are very much still to be worked out as part of those negotiations. Discussions are yet to commence, and we don't have any final details, but some of the objectives that the government will be looking for is the reduction in the number of venues in regional New South Wales that operate gaming machines, support for the ongoing financial viability of regional hotels and clubs, reducing the number of gaming machines operating outside the casino environment, enhancing gambling harm measures, and ensuring that the financial return to the state reflects the long-term value of any licences that are transferred. So it's still very much a discussion at the moment with nothing settled yet.
So you've said discussions are yet to commence, but when was that decision to commence formal negotiations made?
It was a cabinet decision, so I'm not sure I can say much more about exact timing.
But it would have, given that this was reported as government sources have not been as discreet as we've given this was reported as going to cabinet the Monday following the coverage, we can assume it was very recently.
I think that you can assume that the public information about it was related to the cabinet decision, yes.
And who will be involved in those negotiations?
It will be ILGA, the Independent Liquor and Gaming Authority, and the Green Gaming New South Wales. And we might also have some, of course, involvement with our Treasury and Department of Premier Cabinet colleagues.
Thank you. And when are those discussions expected to commence?
We haven't got a date at the moment.
But would it be fair to say they're imminent, given the way it was reported?
That could be right, although I just will emphasise that the team working on casino matters has been quite busy. And so they've got some other things that they're doing at the moment. So I'm not sure that I can give you any sort of exactitude about the date, but I imagine that they'll start soon.
Before you've set out the objectives, before I turn to some of those specific elements, could I ask, in general, rather than about this specific deal, would an arrangement to increase the machines at the Star by, say, 1,000 machines require a change to the law?
I think it might, but I could take that on notice. I think it might depend a little bit too on the actual arrangement that we come up with, but I can take that on notice and just confirm whether it would be absolutely necessary or whether it would depend on the arrangement.
What are the sorts of variables that could take part in a deal which might mean that the law was required or was not required?
I'd really have to take that level of detail on notice.
Okay, thank you. If it's also been reported that such a deal might require the Star to purchase 1,500 licences and then 500 of those might be retired under the existing framework for these machines, asking in general rather than about the specific deal, is that correct?
I can't say anything about the specific number, but I think the concept that the overall number of machines and entitlements would be reduced is part of the considerations.
Yeah, so that's part of the considerations. Would it be required by the existing framework is my question.
I'll have to take that level of detail on notice.
Well, it's a reasonably, this is pretty fundamental to the management of poker machines in New South Wales. It's not really a question of detail, Ms. Webb. If these machines were transferred, if they were purchased, would machines have to be retired?
I just don't want to mislead the committee. I could look up the legislation and try and get some advice during the course of this hearing, if you like. I know there's requirements in various circumstances when entitlements are transferred, reductions in numbers, but the rules are a little complex, and I just don't want to mislead you about that. It would definitely happen on any case here, but there's definitely some requirements in the arrangements that you reduce the number of entitlements when you transfer, but I really would prefer to take it on notice and just make sure I give you a correct answer.
If you could take it on notice in the course of this hearing, that'd be helpful, Webb. I do have to say, I think the public would be alarmed that that general regulatory framework, that general requirement to retire machines, which is of public interest, is unable to be clarified by the agencies for the public, particularly given this deal has been floated and the agency will be negotiating with the casino over this.
No, I'll definitely get you a detailed answer, and I can say as a general proposition that entitlement transfers do lead to reductions, but I just don't want to mislead the committee by saying how exactly that works when I don't have that level of detail in front of me.
Do those retirements still apply depending on whether, regardless of whether those machines are purchased or leased?
That's the sort of detail I just want to confirm with my colleagues.
If you could confirm that specifically, that'd be very welcome. Has the agency completed any assessment, any analysis about what this might mean, what an additional entitlement might mean for the Star in terms of a boost to their bottom line? Industry analysts have suggested it might generate revenue in the order of $100 to $230 million per year. Is that something where there is a state government analysis, either conducted by your agency or by the Treasury, that you're aware of?
I'm not aware that it's been done as of yet, but I imagine that that might be something that would be part of the discussion at the negotiations.
Well, could you confirm that more? Could you confirm the first bit on notice? Has it been done previously? And this is not the first time these suggestions come up, perhaps on notice. Yep. And I might ask you to be reasonably stronger in your response on the second part. This surely would have to be done, wouldn't it, Ms. Webb? This will be part of the process. Can you confirm that?
Yes, because I think it's a relevant consideration as part of the negotiations. So
yes. Can you confirm also that there will be an assessment of what this might mean in terms of gaming revenue back to the state?
Yes, that's definitely one of the issues that I mentioned in, I think, my very first answer, that financial return to the state would definitely be one of them.
And can you confirm that one of the reasons that'll be required is this is moving to a lower taxed gaming environment, potentially in a deal there, so it may have implications for the gaming revenue that's returned to the state?
I think we'd be looking at all aspects of the financial return to the state, the financial impacts to Star, and generally how it would work in terms of the financial arrangements.
Mm-hmm. When did the Star come to the government with this offer for consideration of discussion?
I don't have that date in front of me. I can get it. Some indication.
You'll take that on notice?
Yes, that's okay.
Yep, thank you. And what financial contribution has been considered as a part of that offer? What has been offered apart from the discussion about two venues?
As I mentioned, the formal negotiations have not commenced, and so we haven't actually had any formal offers that would be part of the negotiations.
So no formal offer has been made of either a financial consideration to government upfront, or presumably of these two performance basis. Is that what you're saying? No formal offer's been made?
I don't think a formal offer has been made. I think some indications have been given, but I'm not sure that a formal offer has been made. I've just been advised that Star approached us in May this year, so I can answer that.
In May this year, yeah. And to whom were those indications made, those informal indications?
I don't have a copy of the initial correspondence from Star in front of me, so I just can't say who exactly they wrote to. They might have written to the Minister, or they might have written to ILGA, or they might have written to Liquor and Gaming New South Wales. I just don't have that in front of me.
Okay, but you'll take that on notice.
Yes.
Turning to some of the considerations, I thought your opening information was helpful just to say, here are some of the priorities that we're going to look at. Is one of the priorities that will be examined by the government in considering the potential change to the law, this shift of machines, whether the casino hires more staff and transitions staff to permanent positions as a part of this change?
Hires more staff overall, or particular staff in relation to gaming? Sorry, I don't think there's been a particular discussion about staff in particular, but obviously, you know, if they were having more machines, they might need more staff. If that's, sorry, I might be misunderstanding your question, Mr. Graham.
I'm asking if it's one of the questions government will ask of Star. Is it one of the considerations? Will more staff be hired? Will existing staff be transferred to permanent positions?
I don't have that in front of me as a specific issue that we would consider, but we're not counting anything out, so I guess that could be something we could look at.
And you've indicated that additional harm minimisation measures to be implemented may be one of the considerations that the government may take into account.
Yes, be a consideration for us. And so therefore, staff to monitor the gaming floor could well be a consideration as part of that conversation.
What industry consultation has taken place so far outside of the Star?
As I mentioned, we haven't started any formal negotiations, and that means we haven't started any formal consultations.
Yep. So I take it there's been no consultation is really the punchline to your answer there.
I've been involved in or I'm aware of.
Yes, okay. As a recommendation of the inquiry into the Crown, one of the recommendations has been in relation to an expert regulator, and the government's moved has indicated its view on that question. Given that this is a significant change in the gaming arrangements in New South Wales, when is that change expected to be in place? What update can you give us on the timing of that change?
Sure. So all of those recommendations of the Bergen inquiry are now the subject of quite an intensive work process to work out the implementation arrangements, including an implementation timetable. Obviously, we'll need some legislative change to change the structural arrangements for the regulator. And so that depends a little bit on the parliamentary timetable as well. So we're getting going now that we've got the decision and the government response on getting an understanding of how all that will play out and the time it will take to do.
One of the views that was put by others, prominent figures such as Tim Costello, was that they were surprised that the minister was spending time rearranging poker machines in the state rather than dealing with the pandemic. Not his exact words, but his sentiment, not mine, although I certainly I thought it was understandable. When a question to you, Ms. Webb, or you, Ms. Hogan, when was the last time you and the minister met together with representatives from the hospitality industry to discuss the COVID-19 situation and what support they required?
I was involved in a meeting with the minister and the club sector. I don't have the exact date from recollection, about 3 weeks ago, but I can definitely find that exact date of that meeting. I take it on notice. My people in my team might have been involved in some other meetings that I wasn't able to attend, so I could also just check that as well.
Might just turn to Mr. Rees briefly before handing back to my colleague. Just returning to those questions about Service New South Wales. You've outlined the processing time on average.
Sorry, I can't hear you, Mr. Graham.
I can't hear anything either.
No, are you on mute, John?
Is that,
Yeah,
a little
that's
bit
better.
better? Great.
That's better.
I inadvertently hit mute there. Mr. Rees, you've given us the processing time for those Service New South Wales programs rolled up together. Could you break those down for each of the 3 programs? What is the processing time at the moment?
I don't have the average processing time split out by program, Mr. Graham.
Could you take that on notice
I can
then?
provide that on notice, of course.
Do you have the call wait times for each of those programs?
That information won't be available. So we have a path in our contact centre which takes all of our business inquiries. They can range from inquiries relating to how restrictions are impacting a business.
So, Mr. Rees, you're really telling us you simply don't know how long. You must be running the only call centre in Australia that can't tell the wait time for calls for a particular program.
So we analyse the wait calls for our business customers overall. There's a plethora of reasons why business customers will be calling. We won't have that data split down to an individual program, but we do.
Right. Well, I'm very surprised by that, but can I ask you to take it on notice and consider that answer? And thirdly, before I hand to my colleague, could you are reporting publicly, and I think this is to your credit, the call wait time for business customers. What is the call wait time for non-business customers for Service New South Wales at the moment?
So that would vary depending on the nature of the call. So we have a COVID hotline for non-business calls. That COVID hotline typically operates at around an average wait time of 10 minutes, but like business calls can fluctuate. And then depending on the nature of a transaction that a customer is calling for, we'll have a different level of service agreed with the partner agency for that. So it would really depend on the specific type of call you're interested in.
Could you provide those agreed times on notice?
For any specific types of calls, Mr. Graham?
Yes. In general, for each type of call. I'll hand to my colleague.
We'll provide that on notice.
Thank you.
Sorry, I can't hear you, Mr. D'Adam.
Sorry, in the intervening period, Mr. Rees, I did have a look at the website with the updated data, and one thing that struck me is that in today's figures, you report applications in progress or to be assessed for all 3 programs aggregated, but you've now stopped reporting for each of the business programs, the business grant program, the micro business grant program, the job saver program, the applications in progress. So yesterday I could see that there were 32,783 applications in progress. Today that figure has been omitted. Is that a bit sneaky that those figures have been dropped off, Mr. Rees? Why have they been dropped off from the reporting?
So let me just quickly check the website so I can make sure.
I will do a point of order. I've been sitting here very patiently, but you can't accuse a public server of being sneaky. I think that's inappropriate, suggesting that. So I'd ask you to.
I don't think he was suggesting the witness was being sneaky. I think it was a reference to the government, and the witness can answer in any way the witness chooses. Please don't interrupt the opposition time.
Mr. Searle, the point of order.
Thank you. I will rule. Sorry, I will rule on the point of order. From what I heard, the accusation was not directed at an individual. The question was whether the actual omission on the website was seen as sneaky. If the questions could proceed, thank you.
Answer the question. So, Mr. D'Adam, you'll see the in progress numbers are still included at the top of that web page for the total of all the programs. The individual breakout of that by program was removed today because it was being reported in a way that was inconsistent with the aggregate numbers and would confuse and mislead. I've asked for the more detailed breakdown at a program level to be done in a way that is consistent with the totals, and that will be re-added as soon as it's available.
So are you saying that the numbers weren't adding up?
It was apples and oranges. They were reporting two different ways of viewing numbers, and I think it was confusing.
So which figure should we rely on?
So you have the aggregate.
Are you saying that the aggregated numbers, we can't necessarily rely on those either?
No. So the aggregated numbers are correct and can be relied on. What you'll see in the aggregated numbers is they effectively show two things. They show the number of applications that we are unable to process until we get further confirmation or information provided by customers, separate from the number of applications that are able to be processed. So those are the two relevant numbers. The details that were provided at a program level incorrectly aggregated those two numbers and inferred that all of those were waiting to be processed, which is incorrect.
The opposition's time has expired. I will ask Mr. Banasiak if he's ready to ask some questions.
Yes, I am.
Go ahead.
Can we just talk about cyber security for a second? I think it might be directed towards you, Mr. Brady, or if not, please redirect. How many cybersecurity breaches has Service New South Wales occurred or had over the last 2 years? I know there's at least two because one of my own staffers has received 2 notices to say their data has been compromised, but I just want an overall figure.
Mr. Banasiak, if your question is specific to Service New South Wales, I might ask Mr. Rees to respond.
Yep, that's fine. Whoever you deem the most appropriate.
Are you talking, Mr. Banasiak, purely about Service New South Wales or the broader Department of Customer Service?
Service New South Wales.
Okay, then Mr. Rees should take it. Thank you.
Thanks for the question, Mr. Banasiak. So a little bit of context. Service New South Wales, like most organisations, experiences attempted cybersecurity breaches constantly. That's part of operating the types of services that we do. We've had one cybersecurity incident that has resulted in customer impact, which was the incident that we reported in 2020. Customers may have received multiple letters relating to that one incident as we worked through our process of notifying customers. And for some customers, you may recall there was an adjustment to the impact, which resulted in some customers receiving multiple notifications relating to the same incident.
So there's only been one successful data breach, you're saying?
That's right.
Okay. What has the department learnt, I guess, and what have they improved in their processes as a result of that data breach?
So there's been a huge amount of learnings from that data breach. If I maybe start with the specifics of the system that was compromised there, which was our email system via a phishing attack, which enabled the contents of our email accounts to be exfiltrated. The number of key learnings there. One relates to the technical controls that we had around our email platform. We've obviously introduced multi-factor authentication onto that platform, as well as the vast majority of other externally facing systems across Service New South Wales. That rollout has now covered 95% of all of our externally facing systems. There was a range of other technical controls that were hardened around our use of email, things such as limiting the third-party applications that could be used to access email from mobile devices, as an example. The second thing we did there was revised our information retention and removed about 92% of all email from customer-facing mail accounts. And we're in the process of removing the dependency on email for the transfer of information across all of our business processes and in conjunction with our partner agencies. More broadly, the department the agency as well as the department has a very significant focus on strengthening our cybersecurity posture. There's a program called Program Trust running for the Department of Customer Service that Mr. Brady could speak to. And Service New South Wales is part of that program and is running a series of focused efforts to uplift cybersecurity across a range of measures. Our principal 3 priorities there to date have been the multi-factor authentication rollout that I mentioned, vulnerability management and remediation, and uplifting alerting and monitoring around cybersecurity incidents, including integrating with the new Security Operations Centre that Accenture will be delivering for the department. There's also a significant education and awareness component to that. So we have mandatory cybersecurity training. We have regular dialogue across the organisation and regular reinforcement of common things to be aware of and to look out for, and making it easier for our staff to identify what may be risky, what may be examples of attempted phishing attacks, and cybersecurity, along with risk management, privacy, and a range of other things more broadly, are reflected as one of the pillars of the Service New South Wales strategy and have an awful lot of focus right through the organisation. My executive team meets every fortnight on risk, cybersecurity, and privacy-related issues, so we make sure that it maintains that level of focus for the organisation.
Okay. Can we talk specifically about the COVID check-in app? Because what you have there is a significant amount of metadata around people's habits, particularly where they're travelling, what stores they're going into. How is that data stored, and how is it safely shared to obviously other agencies that need it? So, like, where actually is it stored? I imagine it's stored on a cloud, and is that cloud actually domestically owned, or is it a cloud that's owned by an overseas entity?
So the data for the QR check-in service is stored within its own database. That database is stored within a cloud environment, and that information is stored domestically. It's encrypted, and the only purpose for that information can be contact tracing, and so that information is only used by health for the purpose of supporting contact tracing. We hold that data for 28 days, and then that data is automatically purged after 28 days. And we have added an enhancement to the COVID check-in experience through the Service New South Wales app that enables our customers to look at the history of their check-ins, and that enables you to see the totality of the information that is held within that database relating to the check-ins that you performed.
Okay, but does that function still exist after that 28-day purge? Can they see back further than 28 days?
No, you can't, because we don't retain that information beyond 28 days in any form.
Okay, and just clarifying, you said that it's purely for the use of contact traces. Does that mean that no one within the customer service cluster actually can access that data, and you're purely storing it as a repository, and it's only health staff that are accessing it?
That's correct.
Okay, thank you. I might just quickly, just with the app, what discussions have had within the department around the longevity of how long we'll be using that QR check-in? Obviously, as long as we're in lockdowns, but what's the projection from within the department as to how long you're going to have to support that app?
I don't think we have a position on that. As the Department of Customer Service, we'd very much take, it would be health that would ultimately make those decisions, and we'd take guidance from health and the appropriate governance mechanisms.
Okay, well, I might looks like my time is almost up. I might pass over to my other cross-bench colleagues
Thank you.
and regroup later.
Thank you, Mr. Banasiak. I'll just ask a couple of questions, if I may, before I pass over to my colleague, Mr. Shoebridge. Mr. Rees, just picking up on some of those questions from the opposition in relation to the sort of inquiries to Service New South Wales. Now, I understand that there's an additional 650 assessors have been appointed. I also saw media reports that an additional 350 staff had been employed to help answer inquiries. Is that correct?
Yes, Ms. Boyd, that's correct. The numbers that we have serving business customers, will move up and down a bit depending on demand. But yes, we employed an additional, I think it was about 400 people at its peak.
Are they direct hires or are they through this partner agency arrangement?
It's a combination. We recruit in a combination of ways. So some of those people are recruited directly into Service New South Wales. We will leverage skill hire arrangements where we can that enable us to very quickly increase our capacity, and we'll leverage the support of third parties as well where required.
Those third parties, I understand Datacom has been appointed. Are there other third parties or is it just Datacom?
In the contact centre space, the Datacom is the primary partner that we work with there. I know we were considering recently doing a small piece of work to assist with some of our workload with other contact centre providers, but I'd need to take on notice whether that eventuated.
Thank you. Is Datacom effectively call soaking or are they providing substantive advice?
Datacom have helped in two areas. One is with our inbound call volumes. The role there is principally to help people understand and interpret the health orders as they relate to a customer's particular circumstances, whether that be individual or business. Those health orders are all translated into guidance for customers through the New South Wales government website, and so a lot of the role we play there is helping people understand and interpret whether they are permitted to do what they're seeking to do, or whether they require or have an obligation on them based on the information that is published there.
So we're hearing, my office has been contacted by people who are saying, they called Service New South Wales, they got put on a call list, and then someone calls them saying, oh, I'm from Datacom. I've been asked to call you back, but then are unable to provide any kind of substantive advice, are basically just trying to find out what the nature of the inquiry is to then put them back on a list to be called by someone else. Does that accord with your understanding of how that should be operating?
Look, it doesn't. I'd be disappointed if that's the experience that our customers were receiving. So we'll certainly look into that. One of the symptoms of onboarding a large number of people very rapidly in response to complex needs is, of course, there's a period of time at which competency builds. So there's a chance that that's going to be symptomatic of people who are, very early in their role. But no, our goal is to provide the very best help and the very best service that we can to our customers, and we do have a lot of focus on training and development and quality assurance to continue to help us strive to achieve that.
So were the Datacom people trained before sort of being let loose isn't the right word, but before being in a position to speak directly with people who had contacted Service New South Wales?
So certainly, I would imagine in almost all circumstances, yes, that training is provided before people are taking calls. One of the realities around the environment we're operating in is often there is very little time between when restrictions are changed and when those changes are communicated to the public, and our ability to understand those changes, train our staff, and answer the questions that come in effectively immediately. So we do have sometimes periods where we're unable to provide the level of guidance that we'd like with the with the confidence that we'd like.
So Sorry, just in the interest of time, just one final question, and perhaps you could take on notice information as to exactly what training occurs before people are given lists of people to call. But I just wanted to know across the board, is there training given to people within Service New South Wales, particularly at this time, in relation to managing interactions with the public in a way that minimises the mental health impact? Is there mental health sort of first aid type training given?
There is. So this has been a bigger and bigger part of our training over the last number of years. Probably harking back to the introduction of or to the bushfires that commenced in 2019. Which saw Service New South Wales start to play a bigger and bigger role supporting communities that have been impacted by natural disasters. We rolled out a number of programs to help build those additional skill sets across our team to deal with customers that were experiencing a greater level of anxiety. They range from things like accidental counsellor training, which we found very valuable, and we rolled out dimensions of lifeline-based training as well, recognising that we were becoming more and more likely to be speaking with customers that may be at risk of harm.
Thank you. I'll pass over to my colleague, Mr. Shoebridge.
Oh, thanks, Chair. Mr. Dent, I don't know if you got any of those numbers in the meantime, did you?
I'm just waiting on those to be clarified. I was incorrect. It was 90%, not 91, in relation to police when it comes to TMF-related notifications. I've just asked to get that clarified, so I'll come back to you shortly if that's okay.
Yep, thanks, Mr. Dent. Mr. Rees, the Auditor General made a series of important recommendations about grant schemes in the Auditor General's review. There are a whole series of recommendations that were put out. Many of those were to be implemented by the end of the year. Can you advise the committee how many of them have been implemented to date?
Thank you, Mr. Shoebridge. For grants, right?
Yes, for grants. And we might start with some of those key issues about identifying what the appetite for risk is and putting in place fraud controls.
So certainly Service New South Wales has a defined risk appetite statement that outlines our risk appetite with respect to a range of areas. The delivery of grants, though, in terms of the risk appetite for grants programs, they're not purely about the risk appetite of Service New South Wales. They're risk positions that are ultimately taken by government, obviously trading off the competing demands of the speed at which you want to provide support with the level of risk and compliance related risk that you're prepared to take along the way.
Mr. Reid, for the small business grant, the hundreds of millions of dollars there, what's the risk appetite for that?
For the current small business grant, do you mean, Mr. Shoebridge? So certainly, I think it'd be fair to say that the government places a strong emphasis on the speed at which those funds are delivered. That's resulted in a varied level of assessment depending on the level of grant that is being applied for, and depending on the level on the nature of the applicant for those grants. So in some cases where people are applying for one of the lower levels of those grants are within highly impacted industries, and applications are not tripping any fraud or eligibility flags, those applications may be auto-processed, and applications that are considered to have a higher level of potential risk are likely to be queued for manual assessment.
Yep. So, Mr. Rees, can you tell us what the risk appetite, what the acceptable risk level is for each of the current COVID-related grants that Service New South Wales is providing? That was one of the critical recommendations from the Auditor General.
So please help keep asking if I'm not asking your question in the correct way. So we have a risk appetite statement defined for Service New South Wales. For each of the programs that we're currently delivering, we have put forward a view around the level of risk that government would see with those programs. The decision on the speed at which to deliver those programs and the level of assurance to have before payments are made is ultimately a decision that sits with government.
Yeah, I'm not asking about whether or not you agree with the level of risk or you disagree with the level of risk. I'm asking you what the level of risk is, what the appetite for risk is for each of the current COVID-related grants payments being managed by Service New South Wales. I want to know what the number is, if you like. Is it a 3% fraud? Is it a 10% fraud? Is it a 2% fraud? You must have that because the Auditor General said that was one of the major failings of Service New South Wales in the grants programs that the Auditor General reviewed earlier this year.
I think the question of what is the appetite for risk of government is not one that I can answer. I can certainly take on notice the question around what guidance we've provided and what assessment we've provided to inform that process and to form those decisions.
Mr. Rees, the Auditor General said that it needs to be documented in advance. It needs to be clearly identified what the level of risk is. Now, we've seen in some of the bushfire-related grants, fraud claims going into almost 10%, tens and tens of millions of dollars. I think it's only fair that you advise this committee what the current risk profiles are for the COVID-related grants being administered by Service New South Wales. And I ask again, will you provide us with that detail?
I'm happy to take that on notice, Mr. Shoebridge.
Thank you. Unfortunately, that is all we have time for this round, Mr. Shoebridge. The committee will now take a 15-minute break. We'll be back at 11:15. Can I remind all witnesses and members to turn off video as well as to mute yourselves, because otherwise you will be still be live. So yeah, I will see you at 11:15. Thank you. Welcome back, everyone. I'm just checking that the screen. Yep, there we go. We look like we have everything ready to start again. So we will commence questions from the opposition.
Ms. Boyd?
Yes.
It's Emma Hogan here. I just wanted to advise Mr. Banasiak that I believe the services he was after from the Services New South Wales website have been forwarded to your committee secretariat for him during the break.
Thank you, Ms. Hogan. Opposition.
Ms. Boyd.
Go ahead, Ms.
I'll lead for the opposition at this round, and my questions will be directed to Mr. Rees in relation to cybersecurity, or Ms. Hogan, depending on who wishes to take the question. I think in the last round, or perhaps the round before, there was a suggestion that there was only one confirmed data breach. I was just referring to questions given on notice in the Legislative Council in answer to questions by Mr. Peter Primrose, that in the 1920 financial year there were 56 data breaches reported in respect of state government agencies, and in the following financial year, that is 2021, that had extended to 205 data breaches reported to the Privacy Commissioner. So my question is, does customer service have visibility of all of these reported data breaches? And do you have any indication as to what has caused that explosion in reported breaches?
Mr. Searle, I might direct the question to Mr. Brady, actually, as it relates to the broader department. Mr. Rees looks at Service New South Wales, which is 1/3 of the broader department, but Mr. Brady looks at how we respond to cyber and privacy breaches, and they're not always one and the same thing. So, Mr. Brady, I'll throw to you.
Thank you, Secretary. Exactly the key point there is that cyber breaches are really related to an attack by an external party, whether that's through phishing or some other attempted method of penetration of our systems, whereas a privacy breach can arise from a range of different circumstances. And certainly the largest single cause of a privacy breach in our cluster historically has been through email, where someone's inadvertently attached something to an email, and that's gone to the wrong party. For our department, it had 264 total privacy breaches in 2021, which was up from 125 in the previous year. That actually reflects a growing culture and understanding of privacy within our cluster. So we've been completing mandatory privacy training across our business. We've actually achieved 92% completion of that mandatory privacy training. So as part of an uplift in our culture and understanding of privacy, that we're seeing an increased level of reporting. And also, of course, the mandatory reporting that's now in place under the Fines Act for Revenue New South Wales. In terms of the cyber breaches, we've only had one other cyber breach in addition to the one that Mr. Rees mentioned, and that breach did not result in any customer information being breached.
I think Mr. Primrose's question related to data security breaches. I think that would contemplate pretty much every piece of information that might be electronically stored or recorded or transmitted. Those numbers you're referring to, are they just breaches within the cluster, or is that the whole public sector?
They're only in relation to the Department of Customer Service.
So what visibility does customer service through Cybersecurity New South Wales have about the totality of data and privacy breaches reported across the whole public sector? Like, what sort of superintendent role do you have in terms of seeing all of that information, if any?
I'll take that, Mr. Searle, if you like. So Tony Chapman, who is the lead of Cyber New South Wales, isn't actually called as a witness today, but I'll do my best to answer. Cybersecurity New South Wales plays, I guess, an advisory and central agency role across the whole of government for supporting cybersecurity incidents. And then the IPC, through Ms Gavel, are more responsible for looking at the privacy breaches across all of government. They also sit in the cluster, but they're an independent organisation, whereas Cyber New South Wales is not. So we primarily record the cyber incidents, and we can see if they've resulted in a privacy breach, but we don't look at privacy overall.
Okay, so just to be clear, you don't get visibility of all the reported breaches across the whole public sector?
We would get visibility of cyber security incidents, and sometimes they do or don't result in privacy breaches as well, but I wouldn't as the secretary, nor would my core department, have visibility of all privacy breaches across the sector. That would be a question for Ms Gavel from the IPC.
Right. I see in the evidence to the cyber security inquiry held earlier this year by PC1, Portfolio Committee number 1 in the Upper House, the Charter of Cyber Security New South Wales was described as providing whole of government leadership, coordination, advice and intelligence across New South Wales government. What role does Cyber Security New South Wales actually play in ensuring that the standards and protocols that you've supervised the development of in relation to cyber security measures are actually adhered to by government agencies?
So again, I would take the details of it on notice, but we play a broad role. We coordinate our cyber response through all of the cybersecurity officials, and there is a lead cybersecurity official in each of the clusters across government. And we have various reporting mechanisms where they advise us on the progress of their cyber maturity. They advise us on any incidents that have been occurred, and often Cyber New South Wales will coordinate the response to those incidents, particularly if it relates to more than one agency, like we've done previously. And then we provide guidance and advice around cyber intelligence that we may get from the Australian Cyber Security Centre, or the police, or other forms of intelligence that we feel needs to be advised across the whole of government.
Okay, so just going back, I think, Mr. Brady, to that earlier question about the increase in reported data breaches to the Privacy Commission that went from 56 to 205, and I think you also gave evidence that in relation to the breaches within your cluster, there had also been a big jump. I think in relation to your cluster, you said that reflects a growing awareness of privacy. Do you therefore say it doesn't reflect an increase in the number of actual breaches?
I think it'd be impossible to say, Mr. Searle.
Okay.
We can't say what might have occurred in the past we weren't aware of. But what I can say is the Project Trust, which Mr. Rees referred to earlier, tries to lift not only our cyber security, but also our culture and capability across the cluster. And one of the things that we're particularly focused on is ensuring that we're reducing our use of email attachments. And as I said earlier, that's been the single biggest cause of privacy breaches. So making sure we're using more secure ways of transmitting information within our department, which limits the risk of those things happening, as well as raising the understanding of our staff so that they're aware of the risks and they're avoiding the use of those tools, and being aware of any potential phishing exercises as well.
So in terms of what we do know, though, both within the public sector more broadly and your cluster specifically, we have seen fairly significant jumps in reported data breaches. And I think from Ms. Hogan's evidence, it sounds like what Cyber Security New South Wales does is you work with agencies, you develop these protocols and these standards that agencies are then meant to adopt, but you don't actually provide a compliance or enforcement role. Is that correct?
So we are progressing to play more of a compliance role now, Mr. Searle. The government announced last year through the Digital Restart Fund an additional $240 million to support cyber security uplift across the state, and $60 million of that was allocated to Cyber New South Wales so that we could increase the role that we play across government, both for the larger clusters and to support smaller agencies where required. So we are growing that capability now, and all of those CISOs do report back as to what's going on in their agencies, but only as it relates to cyber and then any flow on privacy or data breach impacts. the privacy details that that Mr. Brady described earlier across government, they can occur through many different mechanisms, and people choose to report those to the Privacy Commissioner, and she would be better placed to comment on whether the reporting has increased because there are more incidents or because agencies have been encouraged to report more often.
Okay, so the first recommendation of the Upper House cybersecurity inquiry earlier this year was that the state government should provide cybersecurity with a clearer mandate to oversee agencies' cybersecurity progress and to ensure compliance. Can you tell this inquiry whether that mandate has been given to Cybersecurity New South Wales by the government?
Yes, so through the additional $60 million that we have been provided, we've been able to expand the team and therefore expand our responsibility across government, and we're responsible not just for leading the sector-wide cybersecurity strategy, but for ensuring that all agencies honour it and monitor it. I wouldn't say that we have all of that in place just yet, as we've only been expanding the team over the last little while, but that is the progress that we're making to that government remit.
Right, but so I don't want to put words in your mouth, Ms. Hogan, but the mandate to Cybersecurity New South Wales to fulfil, if you like, that central agency style role in relation to cybersecurity, to be able to actually enforce compliance by other agencies, that's not yet fully in place. You're building your capability, but you don't yet have that authority. Is that correct?
No. I think the Cyber New South Wales has that's its role to play. I'm just saying I think I would be misleading the committee if I said that we were 100% there, given that we've only just been expanding the team. I would be happy to take on notice from Tony Chapman, who is our lead in cybersecurity, some further detail on exactly what the progress has been and when we expect to see those duties fully fulfilled.
Yeah, so in relation to the $240 million that we heard about in the inquiry, as well as just now from yourself, 180 million is available just to, I guess, the different departments to, and I think the terminology is engage in, quote, targeted cybersecurity uplift.
That's right.
To better manage and address cybersecurity risks, improve the maturity of practice in agencies, blah, blah, blah. What is uplift or security uplift? Are we talking about programs, training, hardware, engineered goods? I mean, the jargon is just impenetrable here. Can you decipher it for us?
Yeah, sure. So it could be for a number of things, and again, I'm happy to get to take a more detailed response on notice from Cyber New South Wales itself. But generally, when we talk about uplifting cyber capability across New South Wales, we're talking about culture uplift. We're talking about repairing systems. We're talking about strengthening the Essential 8. We're talking about strengthening the mandatory 25 requirements that we have in place to ensure that our cybersecurity obligations are fulfilled.
Right, okay. I think I understand that. So in relation to these increased reported breaches that we've been reading about, it does seem that there has been a sort of an inability to hold back the tide. So does that speak to some kind of flaws in the protocols that Cybersecurity New South Wales has promulgated? Does it talk to a lack of compliance by agencies? Like, where are the gaps here that are allowing this rising tide of breaches that we're seeing reported?
Yeah, so without seeing Mr. Primrose's question on notice nor the answer that was provided, I'm not entirely sure where that data has been drawn from. If it refers to data breaches, they may or may not be cyber related. And if it extends to 205 privacy breaches, they also may or may not be cyber related. So I'm not entirely sure how to phrase an answer around that question. What I will say from a cyber perspective is we continue to remediate where we see challenges. We continue to build a culture where people are more cyber and privacy aware. I've issued a circular last year to the whole of the state saying that cyber training must be compulsory for staff, and all agencies are implementing that. I think what is constantly the challenge is, cyber crime is on the rise, and it's global. We're not the only ones that are impacted by that. So whilst we're doing our very best to ensure that we operate in a cyber safe and privacy safe environment, I think that cybercrime will continue, and it's something we need to be ever vigilant about. And we need to be constantly assessing and monitoring, as Cybersecurity New South Wales does, to improve our response.
Do you get any visibility of the reports to the Privacy Commissioner? So, for example, of those 205 incidents, do you know what departments they relate to, whether departments have been the subject of multiple breaches, how many citizens have had their data potentially compromised? Do you have any visibility of that basic information?
No, I would only be able to get visibility of it as it impacted, if it was driven by a cyber incident. I wouldn't have visibility of, let's say, a breach in justice that had occurred because of the wrong email attachment going out, or any other cluster.
So in terms of the cyber incidents, though, do you get visibility of all of those things from the Privacy Commissioner? Is there that information sharing to enable you to do your work, or is that a gap in the system that needs to be remedied?
No, I would say if Mr. Chapman were here, and I'll take his actual response on notice, but I would say that he would say that he has visibility of the various cyber incidents that have occurred across the state.
So he'd be able to tell us what departments have been the subject, whether they're sort of repeat offenders, if you like, or whether they're spread. So through you could provide us a notice which departments have been responsible for those 205 incidents?
Well, if the 205 incidents are cyber related, I would be able to share more information, and I would have to check through.
Could you take that on notice, please, and come back?
Experts. Yes, I will take it on notice, and we will provide what we can, and is not what, yeah, we'll provide what we can.
And of that 180 million for cluster departments,
yeah,
how much of that has been spent to date?
I'd have to come back on the numbers. I can probably do that by the, I can come back and tell you potentially by the end of the session, and if not on notice, how much of that money has been allocated to which department. In terms of what each department has spent that money on specifically, that would be a very detailed response that I would need to take on notice.
I'm happy to have a detailed response, and I'm sure if you need more time than we've allocated, I'm sure the committee would indulge you. That information is very important. Now, Ms. Hogan, in March of this year, the Electoral Commissioner stated, and I quote, "The lack of adequate investment in the cybersecurity of New South Wales electoral systems and personnel over time has meant that the Commission does not comply and cannot comply in the immediate future with the New South Wales public sector's mandatory cybersecurity policies. The Commission also doesn't meet the Australian Cybersecurity Essential 8 standards for cybersecurity," unquote. Now, that's very disturbing coming from the Electoral Commissioner, because it speaks to the potential lack of integrity around our electoral processes. What do you think this is adequate, and has money been allocated to the Electoral Commission to help bring it up to speed?
I'm not, I'd have to take on notice whether the Electoral Commission has actually applied for additional funding through the money that's been set aside for cyber. In this year's budget, we were given an additional, or the Digital Restart Fund was given an additional 500 million, and I think approximately 70 million of that was set aside for additional cyber support, specifically for smaller agencies. But I would have to take on notice whether the Electoral Commission has actually applied for any of that funding.
Fair enough. Now, earlier this year, Cybersecurity put out, Cybersecurity New South Wales indicated through a media release that it became aware in January of the Excellion data breaches.
Yeah.
Now, Excellion in February says that it notified all of its customers on or around December 23. I think in estimates earlier this year, the Minister for Health and the Health Secretary indicated that Health knew or became aware around about Christmas Day or Boxing Day. And we've now learned that the police and cybersecurity have commenced Strike Force Martine in February. So I was just wanting to know when Cybersecurity New South Wales was in fact notified of the Excellion data breaches. Was it in December or at some subsequent point in time?
That's casting my mind back quite a while, so I will have to take the details of that on notice. But I can say that Transport and Health have proceeded to manage those incidents since then.
Sure, but that's not my question. My question really is, do you know when they reported to Cybersecurity New South Wales that the incidences had happened, and when were they aware of the incidences? Because there seems to be some lack of clarity around the timelines.
Without Cyber New South Wales here in the room, I'll have to take it on notice, I'm afraid. I don't have that level of detail with me.
Okay, Madam Chair, I think my time's expired, but I'll return to these themes.
Thank you. I'll ask just a few questions before I hand over to Mr. Banasiak. I just wanted to pick up, Mr. Rees, on the issues we were discussing before in relation to Datacom. Perhaps you could take it on notice, but I'm interested in knowing what percentage of calls to Service New South Wales are being answered by Datacom people, and also what percentage of calls are then, issues raised through that service are being actually resolved by Datacom as opposed to having to be passed on to somebody else. Are you able to provide that information on notice?
Yeah, look, I can provide some guidance, which is Datacom represent a relatively small percentage of our overall contact centre workforce. It would be, I think, in the region of maybe 10%, but I can certainly come back to you on notice with the specifics.
That'd be very useful. And just one last question. I understand that a number of businesses with suppressed ABNs were finding it very difficult to apply for the micro grants in particular, because there was basically, when they went online to do this, there wasn't you had to put in an ABN, and so if you've got a suppressed ABN, it wasn't able to cope with that. I understand there was a workaround put in place where people could call and speak directly with somebody in order for that to in order for them to still be able to apply with a suppressed ABN. But has there been a technical fix put in place for that, or is the expectation still that people will have to call and speak to somebody in order to apply?
I'll have to check. Certainly the ABN controls are there to protect the grants programs from abuse, and one of the key requirements is that you are a legitimate and active business. Those ABN checks obviously give us a strong level of assurance for the majority of the applications. There will be from time to time customer applications that do need additional support from our team in order to be processed. But I'll look into the specific question regarding suppressed ABNs.
Thank you. Mr. Banasiak.
Thank you, Chair. My questions are directed towards Ms. Webb, particularly around the property expert panel. Last estimates, which was on the 5th of March, the Minister announced that the property expert panel had been established, but we weren't able to get an answer on the day as to what the composition of that panel was. It was taken on notice, and the response back was that the composition had been announced on the Fair Trading's website on the 24th of March. My question is, was the actual panel established when the Minister made that announcement, or had he actually jumped the gun? Because it seems illogical that if a panel had been announced at the 5th of March, someone would have been able to tell us the composition.
Mr. Banasiak, I don't think I can answer that question. I don't have any particular briefing on better regulation matters with me today because we were here for the customer service portfolio. So I would have to take on notice exactly the timeline of when the establishment of the committee occurred versus the announcement versus the invitation to members. I just don't have that material with me today.
Okay, well, most of my questions are going to be on this, so I may just defer to Mr. Shoebridge and put these questions as supplementary to you.
Yes, that would be, I think. Thank you.
All right. Thank you, Mr. Shoebridge. It's all yours.
I think Mr. Shoebridge is not, no, he's definitely not online still. So I think we can hand back to the opposition.
Thank you, Madam Chair. Just returning to the cybersecurity matters, under the protocols in place, Ms. Hogan, if a department discovers a cyber attack, who are they meant to report to? Are they meant to notify Cybersecurity New South Wales first and foremost before they do anything else? What level of visibility are you supposed to get? And yeah, so if you could answer that question.
Yeah, so there's a framework in place about what constitutes a cyber incident. So some cyber breaches might be, they might just be an attempt. An agency might have picked up an attempt to get into a system. That might be, depending on the system that it is, that might be considered low risk, and then we move up to a heightened risk and then a significant risk. And I'd have to take on notice the specific threshold, but once you get to a specific threshold, there is a requirement to report it to Cyber New South Wales. That's
okay. In relation to the Excellion incidents, I see in reporting earlier this year that Transport's information got put on the dark web by a ransomware outfit called Flop. It said that Health's data wasn't also put on the dark web, although it was also subject to the Excellion data breaches.
Yeah.
Can you find out and tell us on notice when those two agencies reported to Cybersecurity New South Wales the Excellion data breaches, and when they in turn became aware of their own internal breaches?
Yes, I can.
Okay. In relation to that, I see in a 1 March report earlier this year, Excellion themselves say there were 2 incidents, one in December, one in January. That might explain some of the lack of clarity over timelines. So just can you bear that in mind when you provide us with your answers?
Yeah.
Ms. Hogan, no doubt you'll be aware of this report from the Audit Office about managing cyber risks, in particular looking at transport, and found that there were a number of significant problems in Transport for New South Wales and Sydney Trains around managing their cyber risks. And there's some quite disturbing findings there, including that the senior executives weren't really given visibility of matters, and also that they don't appear to have really met their own benchmarks in terms of cyber security. In fact, I think these risks were so significant that parts of the Audit Office's report had to be redacted, because between December 2020 and this report being tabled, I think in July of this year, neither Transport for New South Wales nor Sydney Trains had in fact identified the vulnerabilities identified in the report. And in fact, even more disturbingly, they weren't aware of those vulnerabilities until the report was done. So my question here is, why didn't Cybersecurity New South Wales have knowledge of these matters until the audit report? Is that because, again, it wasn't your job to superintend the agencies?
Yeah, I'll answer that as best as I can, but as Cyber New South Wales hasn't been called as a witness again, I haven't prepared myself as fully as I might have on cyber had they been called. So I'll do my best and I'll take the rest on notice. I am aware of the Transport report. What I think it refers to is 2 things, and Mr. Searle, of course, correct me if I'm going down the wrong path here. When the Audit Office did that work with Transport, they used what's called red teaming, where they assess, they do some of their own vulnerability assessments, and then when those vulnerability assessments are completed, they advise the agency what they found, and it is the agency's responsibility to then acknowledge those vulnerabilities and to fix them. My understanding is that Transport have been made aware of all of those and are in the process of taking steps to fix them. But the specific details, you might be better placed to ask Transport, because Cyber New South Wales will be aware of the report, and we do in fact get given the opportunity, Cyber New South Wales gets given the opportunity to review the AG's reports from a risk perspective. But the specifics of how that was handled would be a better question for Transport, as they would have led the response on that themselves.
Okay, but what I found particularly disturbing in the Audit Office report was that both of those agencies had cybersecurity plans that were said to be in line with the mandatory requirements put in place by Cybersecurity New South Wales. So that
right.
So that gives rise to two possibilities. One is the plans were in place, but they were crap and they didn't work because you guys didn't design them properly. Or secondly, that maybe they didn't properly implement them, but again, there seems to be a sort of a lack of granularity in the Audit Office report, but it does sound like the two agencies were fully compliant with the requirements put in place by Cybersecurity New South Wales, and yet there were these pretty devastating vulnerabilities when you read the full report. So does that suggest to you that maybe Cybersecurity New South Wales needs to sharpen its pencil and refocus the content of its mandatory requirements across the public sector, particularly if it's going to take on this central agency policing kind of role?
Well, I think, as I answered earlier, that is already the case. We're already, ramping up our own capability on the way in which we work with other agencies and hold them to account. But the granularity of the Transport report itself, I'm not across, and you'd have to ask Transport, or I can take it on notice and get our Cyber New South Wales team to respond in more detail.
Yeah, I look forward to your response on notice, and I'm informed that we did in fact ask for Cybersecurity New South Wales to attend this hearing, but I think there may have been a congestion issue for Hansard in any case.
Oh, okay. I wasn't aware of that.
That's okay. So in terms of taking on that greater superintendence, what time horizon do you see before that is fully realised, Ms. Hogan?
I think from a resource perspective, we're almost there, but I'll get my office to contact me before the end of this session, and I'll come back to you with a more fulsome answer.
Okay, that would be good. One of the other aspects in the report of the Audit Office was in relation to executives in those agencies not being fully informed about the cybersecurity risks and measures. And I think that $180 million that's been provided for clusters to avail themselves is to sort of drive an improvement in culture, particularly amongst leadership elements in agencies. You would agree, wouldn't you, that it's very hard to drive cultural change in relation to cybersecurity if those in leadership are not aware of the issues or the problems?
I'm not sure of the question you're actually asking me there, Mr. Searle.
Well, it's a bit hard for those in leadership positions to drive cultural change in relation to cybersecurity if their agencies are not making them aware of the issues or the problems. You know, you don't know what you don't know. If you're a leader of an agency and you're wanting to do the right thing, if you're not being kept fully informed, that's clearly a problem. Now, I accept it's a problem within those two agencies that have been identified in the audit report, but I don't see why Transport for New South Wales or New South Wales Trains would be outliers across the public sector. Does this suggest to you that there may be problems across the public sector with people in key leadership roles not being properly informed by their agencies about cybersecurity risks and issues? And how will you address that?
I'm not sure. I'm not sure that it suggests that to me fully, but what I can tell you is, you know, at Secretary's Board alone, we report each month, each cluster has an opportunity to present on what their cyber risks are, how they're progressing, what they're doing to culturally uplift, what they're doing to remediate various things. It's taken very seriously at a senior management level. Yes, some of that money that's been allocated has been allocated definitely for culture uplift programs and training. We at DCS alone, we take that very, very seriously, as Mr. Brady mentioned earlier. And clusters do report back to us on how they're tracking with that. So I don't know that it is necessarily all about what executives do and don't know. I just think that cybercrime is persistent, and cyber security breaches or attempts to breach cyber security will continue to occur, and we need to take a continuous improvement approach, as we do with many things, to making sure that our culture is always, you know, across these issues, and the appropriate training is in place.
Okay, one of the concerns in the cybersecurity report of the Upper House earlier this year raised a concern about cybersecurity New South Wales being part of customer service and doing that sort of leadership, maybe growing into a superintending role on cybersecurity, and also being in the same agency or cluster as Service New South Wales, which is a core service delivery. One suggestion was to move cybersecurity New South Wales into the Premier's cluster to sort of give it that sort of independence from service delivery. What steps are you taking while it remains in customer service to make sure that there is that appropriate separation between cybersecurity and the service delivery functions of Service New South Wales?
Yeah, so the Department of Customer Service has been set up to be a central agency. We provide a lot of central agency services, not just Cyber New South Wales. We have data analytics, we have the Behavioural Insights Unit, we have the New South Wales Government Communications Team that provides support across all of government. So we do operate very much as a central agency in many arms of the work we do. Service New South Wales is obviously part of, more so part of our delivery arm, and a very important part of our delivery arm. But the two do operate independent of each other. Cyber New South Wales sits under our Chief Digital Officer for New South Wales, Mr. Greg Wells, and Service obviously sits under Mr. Rees, who's present today, and they operate purely independently. It'll be up to government to form the view as to whether Cyber New South Wales should be moved to the Premier's cluster. But even if that were the case, Cyber New South Wales would need to operate independently in assessing the cyber performance of that cluster, and there are many independents in there as well. So I think regardless of where it sits, it has to operate in a way that is separate from the operational arm of any cluster, as it does with our own.
Yeah, in that earlier inquiry this year in relation to cyber security, there was evidence given. I can't remember if it was from Mr. Rees or whether it was from Cyber Security New South Wales, but some 30,000 customers of Service New South Wales whose data had been compromised or potentially compromised were not able to be contacted by Service New South Wales. And I just wanted you to address that, because it seemed to me quite odd that Service New South Wales would actually have data of citizens, but that data somehow wouldn't extend to contact details that would enable them to be readily contacted. So can you talk us through whether those 30,000 customers have now managed to be contacted?
Yeah.
And if not, what has been the impediment?
So in the spirit of the last answer I gave, Cybersecurity New South Wales wouldn't have any role other than guidance, advice, reporting, and playing a role in governance, perhaps, of an incident like that, regardless of where the agency lay. It does so happen that Service does lie in the Department of Customer Service as well. So I'll ask Mr. Rees to respond to that specific question, because it relates directly to his own incident that was managed with cyber support, but was managed primarily by Service New South Wales itself.
Thank you, Ms. Hogan. Mr. Searle, thanks for the question. I think there's two two key things that are probably relevant here. The first is the nature of the information breach in Service New South Wales. So the information that was extracted from Service New South Wales was from our email accounts. It wasn't from a core system, of ours. That meant the information that was extracted was highly unstructured in its nature. So it could be content within an email. It could be a scan of a handwritten document. It could be a scan of a receipt. So the unstructured nature of that meant that actually the level of information that was able to be extracted and our ability to correlate that information and recognize that that the information that looks like it relates to someone called Damon Rees in this email account and the information that looks like it relates to Damon Rees in that email account are actually the same Damon Rees. Yeah, that unstructured nature plays a heavy role in the quality of the data that we have available. If it had been a breach of one of our core systems, like a customer relationship management system, where you do have those types of details in a structured, reliable fashion, that would be very different. But for us, the nature was very unstructured. The data was very unstructured. The second factor then, of course, is the approach that we took to notification and the guidance around that, which ultimately resulted in a notification process that saw customers mailed via post to advise them of their impact, and very clear guidance not to attempt to contact customers via other means such as email or phone calls, for the risk that it creates not just to the impacted customers but to the broader populace if we use those as a channel for notification. So I think they're the two key elements. Of the 103,000 people that we identified had some level of data impacted in those mailboxes. We were ultimately successfully able to send letters to 63,500 of them. We did that through a range, through a number of rounds. The initial notification round was via secure registered mail, where customers needed to sign for their notification. That was designed to minimise, again, the risk of criminals attempting to impersonate Service New South Wales in that notification process. It also effectively meant that a customer was signing for their own notification, and therefore we were able to provide a greater level of more personalised advice there. We did have a number of those registered mails returned back to us, and a number indicated that the address that we had attempted to mail that customer at was not valid. We did a second round of data matching with Transport New South Wales, attempted to recontact those customers where that letter had been returned to us. We then did a final round for about the 18,500, I think it was, customers that still had not successfully received those letters. And we did a non-registered version the second time round to maximise the possible level of customers receiving those mails. We weren't able to personalise those final round mails in the same way. But if you put all that together, 63,500 customers were ultimately successfully notified out of the 103,000.
Okay. So it's still a lot of people who weren't able to be contacted, and that's one of the themes that came through the inquiry, was concerns about notification. Ms. Hogan, can you talk us through how the mandatory data breach notification scheme will work? What are the what are the requirements on agencies, and what are the requirements specifically for those agencies to tell their customers where there have been these breaches?
I don't have that detail to hand, Mr. Searle. I'll have to take it on notice.
Thank you. The inquiry also recommended the development of a cyber security skills framework for presumably Cyber Security New South Wales to deliver to the workforce across the public sector. Can you tell us where the development of that is up to, or if it is being developed?
I would have to take that on notice also.
Okay. The committee also recommended a review of the cybersecurity policy to make it much clearer to agencies what the standards and benchmarks they're supposed to comply with are to be. Again, I'm happy for you to take that on notice if you're not able to respond.
I can say that the cybersecurity policy was scheduled for review anyway, I believe. So I think that's occurring, but I'll take the details again on notice.
Okay, that's fine. In relation to developing the most appropriate model for cybersecurity standards, both for state government agencies and cybersecurity businesses within New South Wales, the Upper House inquiry also recommended that you, presumably Cybersecurity New South Wales, work with industry to develop those models. Are you able to indicate whether Cybersecurity New South Wales is currently undertaking that work and that they are consulting the cybersecurity industry?
We consult the cybersecurity industry regularly, not just on matters for government, but various intelligence that we see for all businesses, and we pass that on as appropriate. So I think that's a regular part of the work that we do.
Okay, that's good to know. In relation to the Upper House report more generally, I think the government gets 6 months to respond, and it was tabled in March. So I guess that would be sort of September. Are you able to sort of give us an indication, at least broadly, whether the government, presumably through your agency, will be largely accepting the recommendations, or that you might have a different way of responding to them?
My understanding is that government are considering the response, and I don't think the outcome of it is too far away, but I think that's for government to respond to, Mr. Searle.
That's okay. All right. Well, I think those are the questions for me on cybersecurity. Mr. Graham, are you ready to proceed?
Thank you. And thank you, Chair. I just wanted to turn to another of Service New South Wales's activities, so either Ms Hogan or Mr Rees. At the moment, Service New South Wales is one of the services is in relation to tolls paid by people with a tag if they connect their registration via the Service New South Wales website. It indicates the tolls they've paid in the last financial year, gives them an indication about tolls they've paid in this financial year and whether they're eligible or soon to be eligible for toll relief. I was interested in knowing how long those arrangements have been in place and just a bit about the nature of those arrangements to get access to that tolling data as it comes back into government to provide that service to citizens.
I'm happy to maybe address those questions in the first instance, Mr. Graham, if that's okay, and then Ms Hogan, maybe if you had anything to add. So, Mr. Graham, you asked a few questions there. The program was established in the FY 18-19 financial year, so I think we're effectively on our third to fourth year of that program. The program's ultimately owned by Transport for New South Wales as the policy owner. One of the things we do need to do to deliver that program is to effectively ingest the toll information from the various toll providers so that we can perform the calculations and determine whether somebody is eligible for free or discounted registration. To the best of my knowledge, the data that's collected there is used only for the purpose of supporting those calculations, and that program, I don't believe it's used for any other purpose.
And which agencies have access to that tolling information?
I'll double check, but my expectation would be it would only be accessed by Service New South Wales for the purpose of delivering on that program. But I'm happy to take on notice and double check that.
Great, thank you. And those arrangements with toll providers, how many arrangements, how many contracts do you have in place with those toll providers?
There's been some movement since the start of the program, I think, through consolidation of various retailers. So I'd need to I'd need to confirm the current number.
Right. If you could confirm both who the arrangements are with and what's the nature of the arrangements, that would be helpful. Are there any constraints on the use of that information from a New South Wales government point of view in those contracts? You've indicated what the information's used for, but are there constraints in place?
I would expect there would be. Those contracts were originally put in place sort of 3 to 4 years ago now, so I'd need to take on notice the specifics of those constraints. And
it's relatively continuous disclosure of the tolling data, isn't it? It's that information's flowing in. Is it in real time, really, so people can see?
I don't believe it's quite real time, but it does flow in on a regular basis to enable those transactions to be performed, those calculations to be performed accurately as part of delivering that service.
Yep. And how many, can you tell us then on the basis of that information, how many toll tags have paid at least one toll on Sydney toll roads in the last financial year?
I don't have that information. I need to take that on notice.
Yeah, if you could take that on notice then for the last couple of financial years, that would be helpful. And perhaps you might need to take this one on notice then as well. Could you tell us the value of the tag with the highest toll burden in the last financial year?
I need to take that on notice.
Right, thank you. You've indicated what the uses of the information are. Is the data used to make policy decisions to drive government decisions around tolling?
So any policy decisions in that space would not sit with Service New South Wales. It would sit with Transport for New South Wales. So I can certainly say that Service New South Wales don't use that information in that way. I'd have to take on notice whether that information's supplied to any other agencies in order to support policy making. Thank you.
And is there any additional information supplied to government in a summary form? Maybe it's de-identified in this case that might be used for that policy making, or is this the key flow of information about toll burdens?
I think that question would be best directed to Transport for New South Wales. The information that we receive is the transaction level information specifically to enable us to determine eligibility for those registration discounts.
Right. Okay. Following the estimate in March, a range of questions on notice were asked, and the agency provided information in relation to a range of those. Can I ask, I'll indicate specifically which ones I'm requesting, but can I ask that you update on notice the information you provided in that instance for the relevant time period? So that was a set of requests about toll relief data, and it was questions on notice 623 to 632. Some of them the agency indicated were really a matter for Transport, but customer service provided a range of those on notice. If I could ask that you could update those, that would be helpful.
Of course.
And I might, on that note, hand back to my colleague.
Mr. Graham or Madam Chair, Ms. Webb does have some responses from earlier in the session, if you would like them now or towards the end.
Thank you, Ms. Hogan. That would be very useful, actually, Ms. Webb.
Sure, thank you. Just in relation to the negotiations with STAR, I mentioned DPC and Treasury would be involved in those. I'm also advised that Justice and Communities and Regional New South Wales will participate. I can confirm that we don't have a date yet for the start of the discussions and the negotiations, but the expectation is sometime in September. I can confirm my previous answer about the issues about gaming revenue will be much part of the negotiations, and modelling impacts on revenue will be a relevant consideration as part of the design of the arrangements. In relation to the forfeiture of machines, the trading, if the forfeiture is via a trading scheme, then the forfeiture rules would apply, but that again is a part of the negotiation, whether it's part of the current scheme or whether some new arrangement is put in place. That if it was part of the current scheme, it would depend on whether it's leasing or purchasing arrangements that are put in place. So whether Star purchases from other entities or whether it leases the machines. And the mix of leasing and purchasing will also be part of the design consideration. So I think my short answer to that is it's all up for grabs as to how exactly that reduction in entitlements would work. Legislative change might be needed depending on the design of the scheme. For example, a hotel can only currently sell or lease a gaming machine to another hotel. And so if a hotel wanted to sell or lease to Star, we might need some legislative change to do that. The financial contribution from the Star will be very much a part of the negotiation, and so I can't comment on anything in that yet. The issue of staff for permanent positions at the Star has not been part of the considerations to date, but would be part of the negotiation. I think I've confirmed about how minimisation is a clear part of it. We haven't undertaken any consultation, as I mentioned, and the timing of that consultation will depend on the negotiations with Star and the details of the scheme. The letter from the Star that I mentioned that was sent in May was addressed to Minister Dominello.
Fantastic. Thank you, Ms. Webb. Back to the office.
I might just ask a couple of questions to clarify that and then hand to my colleague. You've outlined now a range of agencies who will be involved in that negotiation. Who is the lead agency for that negotiation?
It will be Department of Customer Service.
Yep, thank you. In relation to the forfeiture question, so I understand the view you've put. It may be that it's not within the existing framework. It may be some other framework structure, in which case there may not be forfeiture. If it was within the existing scheme, if the machines are purchased, there will be forfeit. If they're leased, there will not be. Is that correct?
That's the current scheme. I think just your previous assumption that there might not be forfeiture, there also might be more forfeiture. So I just want to make sure it's clear that it's completely open
and to be
how it would work.
Yes, no, understood. But despite the fact that the leaks from the government, the public reporting suggested that 500 machines would be forfeited. In fact, as you're reporting, as negotiations are yet to commence, as you say, it's all up for grabs. That may or may not end up being the position.
That's right. I understand that's part of the design considerations.
Thank you. In relation to, can I just ask you this question? Thank you for the other clarifications. That's all helpful. Can I just ask you this question as well? This, as we saw, the company value up more than $200 million at one point. This is market sensitive information. The government initially leaked some of this through the paper. Some source in government did. The government, as I understand it, hasn't confirmed publicly that these negotiations have been scheduled since that cabinet meeting until you helpfully did this morning in relation to a direct question about it. Why has the government not confirmed publicly, given this is market sensitive, that these negotiations have commenced? Can you shed any light on that question?
I think I'd just like to clarify that I thought I just said the negotiations hadn't commenced.
Well, that I forget your words from this morning, but negotiations have not yet commenced, but the formal negotiation process has been initiated. That is, we're selecting who will negotiate, we're inviting an offer. Why has the government not made that clear?
I don't think I mentioned about inviting an offer, so I don't want to confirm.
Sure, understood.
We have done that, but I can't answer that question. I'll have to take it on notice because you're asking me about the government's position.
Thank you. I might hand to my colleague.
Thank you, Madam Chair. I think this was a question that Mr. Shoebridge broached in relation to extending the presumptions in the Workers' Compensation Act to cover workers who suffer adverse reactions from being directed to undertake a COVID vaccine by their employer. Now, I commence my question at the outset by saying I'm unashamedly pro-vaccination, quite extremely so. So I don't have any time for vaccine resistance or avoidance. But, for example, where workers are being directed as a condition of their employment to be vaccinated, and many workers have insecure work. They're casuals. They only work from shift to shift. If they get ill and they can't work, they can't earn, they can't provide for their families. And so, leaving aside their own personal preferences, that they're potentially being unwell for work is a barrier potentially to up to a quarter of our workforce getting vaccinated. So in relation to the incidences of people having adverse vaccine reactions, have you, I think this is a question to Sarah, have you actually obtained information from health about how widespread that phenomenon is, and therefore if that presumption were legislatively extended to all workers who were directed by their employers to get vaccinated, what the potential impact on the scheme could be? Can't hear you, Mr. Dent. I think Mr. Dent is still turned off.
We still can't hear you, unfortunately. No.
We can't hear you, Adam.
Can you hear me? Mr. Dent can hear me, but we can't hear Mr. Dent.
No. I know Mr. Dent also has answers to Mr. Shoebridge's earlier questions as well, Madam Chair, so I'm not sure if you'd like him to report them on notice.
That'd be very useful, Madam Chair, assuming we can get Mr. Dent online.
Apologies, is that any better?
There we go.
No,
excellent.
apparently that thing has just given up the ghost. It said I wasn't on mute. I'm very sorry, Mr. Searle. So, sorry, I got a bit confused by the microphone going all wrong there. So the question was around whether we have health advice on the prevalence of the issue.
So for you to advise on the potential impact on the scheme finances, you have to know what is the likely phenomenon, and there must be health advice. I mean, we're hearing, for example, with AstraZeneca that adverse reactions are like 1 in a million, so that's pretty low incidence. So
that is correct. The adverse reactions are quite low. What we've asked our actuaries to do is look at the data, not just from New South Wales, obviously, but more globally. There are limitations in terms of, given how new vaccinations are, it's a sort of set of data. So there is a lot of assumption going into it. So we have asked the actuaries for updated advice. That hasn't been received as yet. So we are working on understanding what the longer term impact would be of those type of claims. But to the point we started with, it might be worth just clarifying. I did to Mr. Shoebridge say there were 759 COVID-19 related claims since the commencement of the pandemic, of which about 175 are classified as other, which relate to include notifications relating to potential vaccine related claims. And of those, the TMF related ones, a number were police. So they're only notifications in relation to some reaction to the vaccine. So it's 175 out of 759 claims sit in that category. So at the moment, we have asked for advice on, given all of the prevalence and the type, it might also be the sort of the nature of the injury, if you will. So the AstraZeneca data you referred to is talking about a severe reaction, potentially including death, is 1 in a million. We need to understand the parameters of what type of injury would be considered for a workers' compensation claim. So we have asked for that advice. It's not complete as yet, but it's certainly a consideration where we're looking at it as the overall sustainability of the scheme. In the meantime, though, just in relation to your comment on hesitancy, CIRA is preparing guidance for insurers on how to manage claims that do arise from vaccination. So those claims are arising and are being considered by insurers at present. So that there's no, the lack of a presumption isn't stopping those claims, obviously, from being made. And I did mention before, if there's a causal link with employment and the employment is a substantial contributing factor, that would be considered. So where a vaccine is mandated by either the employer or a public health order, it's more likely that that connection is going to be able to be established. And then the insurers will consider that on a case-by-case basis. So we are sort of obviously, from our point of view, encouraging people who think a vaccine-related injury might be related to work to obviously make that claim for it to be assessed.
Okay, but it does seem to me, a fairly sensible measure to take to give additional comfort for workers, and also to remove any economic negative from potentially being vaccinated, and that would all be to the public good. So what's the time horizon for getting that actuarial advice?
I understand it's imminent, but given the parameters being so unclear, the overall value of that advice is something we're not quite certain about yet. However, we are looking into it. We will be providing advice to government in the next sort of week or so for them to consider if they'd like to take some form of action in that relay.
Could you also inform the committee of the result of that information that you've gathered?
Certainly happy to take on notice if anything substantive comes out of that information, yes.
Okay, thank you. Well, what I'm interested in is the potential impact on the scheme finances should every worker be covered by the presumption for getting a vaccine test.
Certainly, and we're certainly very interested in that precise answer too. The challenge is how precise that answer can be at the present.
Yes, but within the limits of the information you gather, I would like to understand what you've got. In relation to the McDougall review, I see there was a release from your minister and the treasurer yesterday, basically saying the government's going to implement all of those review recommendations. One of the recommendations, number 45, was to extend CIRA's investigative powers in relation to iCare to the extent necessary. I think Mr. McDougall found that CIRA had power over workers' compensation insurers generally, but its powers in relation to CIRA, iCare specifically, were unclear. Now, has that proved to be a practical problem in your experience in terms of getting iCare to do what it should be doing?
Respectfully, Mr. Searle, I've had 7.5 weeks to make that judgment, but I think my predecessor made clear in her submissions to the McDougall review that there had been a range of gaps in our powers as it related to iCare and the nominal insurer in particular. So those were provided in our advice to Mr. McDougall, and he accepted, as has the government now in accepting those recommendations, that there were gaps in CIRA's powers. So I think that's now sort of a matter of fact, if you will. We welcome that the government has decided to accept that recommendation and look into what powers CIRA now needs to enable us to take our role fully with iCare and the nominal insurer. I think it's fair to say, while I haven't been here long, having read what I've read and seen what I've seen through the parliamentary inquiries and the like, those gaps were evident.
Okay. Well, in relation to that, moving to a very specific example, at budget estimates earlier this year, it was revealed that of the 23,000 injured workers who had been underpaid by iCare, that only 24 of those 23,000 had been properly paid. And I think it was the evidence of Ms. Donnelly. That iCare, that CIRA and iCare still hadn't worked out an agreed methodology. Can you tell us whether an agreed methodology has now been agreed and what the estimated time horizon is to repay those 23,000 underpaid injured workers?
I can answer that question in part. So the remediation of pre-injury average weekly earnings program that Ms. Donnelly would have referred to at that point in time has obviously progressed substantially. iCare have reported at this point in time, or at the point my data was up to date at 13th of August, 321 underpayments have been estimated with a value of $3.4 million. And at this stage, 98 of those have been remediated to a sum of $938,021 by iCare. So at this stage, that the methodology has been determined and is currently being used by iCare. The process of remediation is ongoing.
So you don't have an estimation as to when the full 23,000 cases will be reviewed and resolved?
I am looking.
Are we expecting it to be a year or 2 years, or?
Certainly expecting it to be sooner than that. From my point of view, a day longer than it needs to be is obviously too long, and we're working with iCare to make sure that process is expedited as best as possible. My understanding is that now that the majority of letters have gone out to those potentially eligible workers, the information is now coming in to be assessed for each of those claims. So I understand the process is underway, but at this stage there's still a significant way to go. I'm just looking, sorry, and I can't see in the notes I have in front of me whether iCare have committed to a particular date at this point in time.
Okay, I'm happy for you to take that on notice and come back to us.
Happy to provide that to you.
Ms. Donnelly said at estimates that the situation was concerning, that it was unsatisfactory, and that it didn't meet community standards. What steps has CIRA taken to make sure that there aren't repeated incidences of this, let's face it, wage theft?
Look, first of all, I certainly agree with Ms. Donnelly that it is quite concerning. One underpaid worker is one underpaid worker too many from the point of view of CIRA. Through this process, obviously, we're asking iCare to provide regular updates. I've chaired a steering committee at which iCare have provided those updates as they progress through the remediation program. We've also continued to work with iCare through that steering committee to look at the Deloitte commissioned report on the methodology that is being rolled out, and to make sure that's, in our view, fair, timely, and appropriate. And we will then, through that group, particularly as it relates to the methodology and its execution, monitor the rollout. So we are keeping an eye, to the extent we have powers to do so, on whether that's occurring. Part of that process was for the steering committee, through that Deloitte commissioned report by iCare, to look at how it could be remediated so there were no future issues. Sorry, I'm stumbling on my words there, but there was a date up to which the problem was originally believed to have occurred. We have asked iCare, and iCare are looking at making sure that the calculations from that date have also not led to any further problems. So CIRA continues to monitor essentially the remediation program and monitor that the methodology being used by insurers is accurate and appropriate.
Okay. Okay, well, that's useful to know. In budget estimates in March 2020, your predecessor, Ms. Donnelly, confirmed that she had required iCare to undertake a review of the Treasury managed fund, and that CIRA was commencing an audit of the self-insurers and specialist insurers. And this was in relation to the fact that in only 10% of cases was the TMF getting things right, and there was a 30% incidence, I think, of underpayment to injured workers. Fast forward a year later, in March of this year, at estimates, I think Ms. Donnelly indicated that notwithstanding the lapsing of 12 months, she was still finalising the terms of reference to undertake a compliance and performance review of the TMF. Can you update us as to where these matters, including CIRA's own inquiries, are up to?
Certainly. So on the pre-injury average weekly earning miscalculation issue, iCare have commenced their remediation of TMF-related claims as part of the process. So the first round was through the nominal insurer, the second round then through TMF claims. I have, by next week, expect to see the final terms of reference for CIRA's compliance and performance audit of the TMF that Ms. Donnelly would have referred to. I intend to have signed that off by next week so that that can commence in earnest in September.
Given that these matters were flagged with clarity in March of 2020, how has it taken, 18 months or more to actually get these various reviews underway?
I can't answer that with any certainty. Obviously, given I'm 7.5 weeks into the role, I can't speak for my predecessor. What I would say is, throughout that course of time, this particular audit of the TMF hasn't commenced, but that doesn't mean CIRA hasn't continued to monitor the performance of the TMF and its return to work, for example, through iCare.
Okay. If you could take on notice and provide us at least an institutional response to the delay.
Happy to do that.
Notwithstanding the moving on of the Chief Executive, because I find it very concerning given the nature of the problem that was clearly identified in budget estimates in March of 2020, that here we are and well into the second half of 2021 and things haven't really commenced. It's a concern to me at least.
I'll certainly take that on notice and come back with an answer.
Yep. Returning to the McDougall review and the indication that the government will seek to legislate, the indications in the Minister's press release is that CIRA will be carrying out further consultation on 4 particular matters flagged by the McDougall review: threshold test for entitlements, entitlement to medical treatment and access to lump sums among them. Just in relation to the entitlement to medical treatment, there's this discussion, which is at page 273 of McDougall's report, which really goes to the threshold for medical benefits. At the moment, the test is what is, quote, reasonably necessary, unquote, and that's been in the legislation in various forms since the late 1920s, I think. And, it's a fairly imprecise formulation, but it seems to admit of a reasonable spectrum of possibilities, given that on a given fact situation, even medical professionals will vary in their diagnoses and in their recommended treatments. So it seems to have been a sensible approach. But the move, as is mooted, to a double test of having treatment which is both reasonable, but then separately assessed as also being necessary. Necessary in that context takes on a certain objective quality. And the AMA and even iCare itself has said that would represent a raising of the bar before injured workers can access treatment. Now, given that all of the stakeholders were consulted in the McDougall review process, and I see their responses from unions and injured workers representatives and even the AMA, as well as iCare's own view, what more do you hope to learn through further consultation? And does the government just already have a predetermined view about making this change to make it harder for injured workers to get medical treatment?
Well, certainly I can't answer whether the government has a predetermined view, but in terms of the advice CIRA would provide, we're very much open to explore whether there would be any potential negative impact on access to entitlements for injured workers. From our point of view, obviously there is a scheme sustainability element, but there is also the need for an injured worker to get the right and appropriate support should they be injured. So we would want to understand through the consultation whether there was any likelihood that an injured worker would suffer a reduction in benefits, and of course whether there was any advantage to the scheme of that. So there's both sides of that equation that would need to be considered. So as part of the overall addressing of those 4 recommendations, we'd be looking for whether one test or other was more appropriate, or whether there were potentially alternative options for thresholds. So I acknowledge that there are certainly views that second test of reasonable and necessary is preferred by some stakeholders. We just need to be sure before we provide advice to government that the overall picture of ensuring the perspectives of both injured workers and insurers is well considered before we provide that advice to government.
Fair enough. Just on the issue of scheme sustainability, in budget estimates, I think earlier this year, the issue of medical bills in New South Wales being significantly higher than anywhere else in Australia was canvassed, and I think the minister indicated he would have CIRA undertake a review or get a report from CIRA on the issue of soaring medical costs in the New South Wales scheme compared to the rest of Australia. What has CIRA done in terms of preparing that report?
So CIRA, as I understand, has completed the initial healthcare review throughout 2019 and 20. That report was published publicly in December 2020. Since that time, we've now published our value-based healthcare outcomes framework, which provides our pathway for monitoring and reporting on healthcare outcomes and the costs in that scheme, so increasing the transparency around that. We have subsequently consulted on and we've proposed changes to surgical and medical practitioner fee orders. We've started publishing a quarterly dashboard now on healthcare costs and outcomes, so again, focusing on transparency. We've updated workers' compensation guidelines for the approval of allied health practitioners to strengthen those approval requirements. And we're in the process of a series of work groups and workshops, with insurers and the medical profession on payments, and having roundtables around a transition to a value-based healthcare framework. What's worth noting is the degree of increase in medical costs over the course of 2021 hasn't obviously matched the sort of more astronomical increases over previous years, but there's a reasonable chance that that's because of access to COVID-19 related delays in access to things like surgery and the like. So the consultation at the moment is ongoing with surgeons in particular, but we expect that we'll be able to come to further conclusions on that in the near future. But work is underway, given that report is now complete.
All right. The independent review conducted by Janet Dorr, which was also, I think, commissioned by Searle, which also fed into the McDougall review, found, for example, that there were a number of problems impacting return to work rates, including the lack of qualified or experienced general practitioners and medical practitioners generally, particularly in country or regional settings in New South Wales. What's Searle done to address that situation?
I don't know that I have that in front of me, so I'll have to take that on notice and come back to you on that specific point.
One of the issues broadly that the Dorr review found was that a lot of scheme deterioration, particularly the deterioration of the nominal insurer, was around claims management and also around return to work rates. Now, interestingly, these were two key features of the PricewaterhouseCoopers report that the government based its fairly drastic 2011 workers' compensation changes on. So it seems to be that, despite the very significant legislative change, these two persistent problems remain unaddressed. What are your plans as now the head of Searle to tackle those two key problems, which are driving scheme deterioration and which are totally out of the hands of injured workers who are paying the price for this?
Well, certainly the report by Janet Dorr obviously led then ultimately to the report by Mr. McDougall, that is now the current sort of primary report which we're operating from in terms of the recommendations. From our point of view, the claims management experience needs to improve. iCare have their nominal insurer improvement plan, in particular that relates to claims management and their claims management model, which is a large part, I think McDougall found, in terms of the deterioration since 2018 of the performance of return to work. We are single-mindedly committed to monitoring the performance of that improvement plan and seeing that iCare does implement the changes required. I acknowledge that those changes are complex and will take some time. So our work will be to set expectations with iCare and make sure that there's no further deterioration to any extent possible while those improvements are being made. They are, as you say, the two most significant drivers and the two things that are of greatest concern to us. So our expectations are being set. We'll have a plan over the course of this year and next where iCare will understand precisely what we're looking for, and it will be about the delivery of those plans they've committed to post-McDougall. So their improvement plans set a pathway to address both return to work and claims management, and we'll be making sure that they meet the milestones and the commitments they've made throughout that process. Meanwhile, at any other opportunity where we can drive programs or projects to improve return to work, we'll undertake those.
Okay, well, I might return to some of that if I may, but I've got one particular issue which I think maybe for Ms. Hogan to either take on or delegate as she sees fit, and that relates to the permits that workers need to access to be able to work either outside those 12 LGAs of concern, where there are the extra restrictions over and above the standard COVID restrictions. And there's significant feedback from culturally and linguistically diverse communities about the difficulties they're experiencing navigating their way through the system to actually access those permits to enable them to perform the work they have to support their families. Can you tell us about how Service New South Wales is tackling the difficulties that those workers and communities are experiencing, where their command of English is not great and where there are these linguistic barriers?
Sure, I'll defer that question to Mr. Rees if that's okay. They're issuing those permits.
Thanks, Ms. Hogan. Mr. Searle, there's two permits that were introduced and came into effect at 12:01 a.m. Saturday just gone. One was the the travel permit, and there's really three reasons that drive needing a travel permit. I think the example you're referring to is specifically for authorised workers within the areas of concern to travel to regional New South Wales. There was also the nominated visitor permit introduced at the same time. We've had 118,000 of the travel permits issued and 12,000 of the nominated visitor permits issued to date. Overall feedback is that is a simple experience, and I think the volumes are reflecting a significant uptake there. There's two things that we'll continue to look at to make sure that is as inclusive as it can be, and to specifically make sure that customers from any of our called communities aren't disadvantaged. One is that we will soon be able to process those permits and issue those permits for customers through the Service New South Wales Service Centre. We can currently guide a customer by phone through applying for that permit themselves, but we'd like to be able to extend that, particularly for customers that don't have good access to digital services, and we'll be able to take that application for customers by phone and post them out the associated permit. The second part of this is working closely with our colleagues in the department more broadly around the communication and the engagement across all COVID-related activities. nsw.gov.au is our primary vehicle for communicating to customers around COVID restrictions and the various dimensions that support that. There's a lot of focus through that team around making information available in a range of languages and using a variety of mechanisms to ensure that those messages are getting out to all parts of the community. That's an ongoing priority for us across all of the work that we're doing.
Thanks for that, Mr. Rees. I might ask this question to, I think, Ms. Webb. I just wanted to turn to the series of outdoor dining trials that are in place. There's 4 that have been announced variously, the Rocks and City of Sydney, initiated by the government, a New South Wales wide one and a Newcastle one, which the government was encouraged to extend these to. Put the Newcastle one aside, the other 3 trials conclude on the 31st of October this year. What happens at the conclusion of those trials? What does that mean for those businesses who've currently got people dining outdoors, particularly as we may well be still in the grip of the pandemic at that moment?
I'm not sure anyone's got anyone dining outdoors right at the moment, but understand your question that might be the move. And so negotiations are going on about the extension of those trials and indeed the expansion of them, recognising, I think as you're implying, that it might be a useful COVID safety measure to allow more outdoor dining. So that's certainly going on.
And could you tell us how many venues have taken up each of those trials, each of the Rocks, the City of Sydney, the New South Wales trials?
So City of Sydney, there were 240 approved outdoor dining activations. I've got a combination figure for the Rocks and Darling Harbour of 49.
Yep.
I think I've got anything apart from that for other areas. I can tell you that some other councils, sorry, I'll just...
So perhaps on note, I'm just conscious of the time as well. On notice, could you let us know how many venues have taken up, including that New South Wales trial, and how many councils have taken up that opportunity for the trial?
We've got Randwick, Parramatta and Narrabri, but I'll take it all on notice.
Yeah, thank you. And I might hand to my colleague just to see if there's any final questions from Mr. D'Adam.
I might just direct one last question to Ms. Hogan, coming back to the question of the $37 million cut relating to employee expenses. I just wanted to get some clarification around that. So has the department been issued with a revised budget allocation letter that confirms that that saving will no longer be required to be achieved?
Yeah, so Mr. D'Adam, I'm not sure to which 37 million that you are referring, or if you've got a,
this is for service
looking at an annual.
Service New South
Oh, it's for
Wales
service.
operating expenses, employee-related costs go from the 2020-21 budget 298 million down to 261 million. So there's a $37 million reduction in the allocation for employee-related expenses. Obviously, that's, you're putting employees on, you're not cutting employee-related expenses at the moment. Is there an expectation that you will, at the end of this budget year, you'll have to still meet that $37 million cut, or has there been some formal communication from Treasury that saving is no longer required?
Right, I see. Mr. Rees, do you have any comments you wish to make there?
Yes, look, I think probably the primary area that Mr. Searle's referring to relates to the funding that was in place for the additional 1,000 staff to support COVID through the previous financial year. When the budget was established for Service New South Wales at the commencement of this financial year, it was done on a certain set of assumptions at the time, and the funding for that additional staff to support customers and communities through COVID was provided for 6 months rather than the full 12 months, with a view that we would engage with Treasury in a discussion at the 6-month mark to see where we stood. Obviously, the conditions that we're operating in now are incredibly different from the conditions that were in place when the budget was established. That has seen the introduction of a range of additional measures that have placed further demand on that COVID funding, and so we certainly are in active conversations with Treasury through my colleague Mr. Brady and our Chief Financial Officer around the rate of expenditure of those COVID-related funds, and at this point, I think it'd be reasonable to say we expect to seek an extension and increase to that funding available.
Right, but that hasn't occurred. There's been no formal agreement reached with Treasury in relation to the quantum of that.
I might defer to my colleague Mr. Brady on the specific status of those conversations.
I also think, Mr. D'Adam, it would be fair to say that we're constantly reviewing, as all agencies are, their funding requirements to support the various COVID initiatives. So it wouldn't be unusual for there to be a short gap in what's approved what's approved ongoing versus what's approved in the moment. Mr. Brady?
Yeah, no, that's absolutely right, Secretary. We're in ongoing discussion with Treasury around the pressures on our business in supporting a range of different initiatives, and those we're getting some approvals coming through on various specific programs, and then there'll be some further approvals that will be sought later in the year when Treasury washes up a range of different impacts, not only across our cluster but others relating to COVID. So we expect that we'll be extending support for the particular group of staff members that Mr. Rees was talking to.
Thank you, Mr. Brady. That does conclude the opposition's time. I just want to check in with the government members that they don't wish to ask any questions before we wrap up.
Well, sorry, Mr. Farlow, I didn't realize. Scott, what would you like to say? Well, I'll ask Scott a question.
I was just saying nothing from me, but go for your life, Shayne.
Yeah, and nothing from me. So the two Ronnies.
Excellent. Very good.
Well, we've got plenty of questions we can fill up the next 15 minutes with, Madam Chair.
No, that's not the agreement. That is not the agreement. Well, we can ask questions.
So I think on that basis then that concludes the hearing for today. Thank you very much to our witnesses for your attendance today, and thank you members for a very orderly virtual hearing. The committee secretariat will be in touch in the near future regarding any questions that were taken on notice and not already answered, and also any supplementary questions that may be asked. I will remind members we need to have a short deliberative once the live stream has been turned off. I'll say farewell to our witnesses. Thank you.
Thank you very much.
Thank you very much.
Goodbye.
I'll just wait for the committee team to confirm when we're no longer live streaming.